A very good morning to all of those who have tuned in. It's early Saturday morning, and the University of Malaya, the Faculty of Law, is very happy to welcome all of you. I will now request the welcoming speech that will be made by our Dean, Dato' Associate Professor Dr. Johan Samsudin, who will give us the welcoming speech, followed by a keynote address from YB Dato' Sri Azalina Osman, which will be broadcasted to us. I now invite our Dean to address all of us.
Thank you, Prof. Philip. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi and salam sejahtera. Good morning. I'd like to acknowledge the participation of Yang Berhormat Datuk Sri Azalina binti Datuk Osman Said, Penasihat Khas Perdana Menteri Hal Ehwal Undang-Undang dan Hak Asasi, penceramah-penceramah yang dihormati, Tan Sri Zainun binti Ali, Tan Sri Datuk Muhammad Arif bin Muhammad Yusof, Profesor Andrew Harding, Profesor Kevin Tan, Profesor Ajang Philip Koh, Profesor Emeritus Datuk Dr. Shah Salim Faruqi, Ms. Karen Chia Yilin, Encik Muhammad Nazim Ganti Syari, dan semua para hadirin yang dihormati. Selamat datang ke seminar Does the Constitution Matter? Lessons from the Malaysian Constitution During Times of Crisis. Kami sangat mengalu-alukan penyertaan Yang Berhormat Datuk Sri Azalina Datuk Osman Said, yang merupakan seorang alumna ternama fakulti kami, untuk menyampaikan ucap pertama seminar ini. Portfolio Yang Berhormat sebagai Penasihat Khas Perdana Menteri dalam hal ehwal undang-undang dan hak asasi adalah sangat penting dan kritikal buat negara kita yang sedang melalui keadaan yang agak mencabar. Kami di fakulti berbangga dengan pencapaian Yang Berhormat dan berharap kedudukan penting Yang Berhormat akan membawa perubahan positif kepada masa depan negara. Welcome to this timely seminar on Does the Constitution Matter? Lessons from the Malaysian Constitution During Times of Crisis. We are deeply honored to have Yang Berhormat Datuk Sri Azalina Osman Said, one of our faculty's illustrious alumni, to deliver the keynote address. This year, we commemorated our nation's 64 years of Merdeka and 58 years of the formation of Malaysia. The celebrations were very muted because our nation is going through a debilitating health, economic, and political crisis of a magnitude never before experienced. How has the Constitution fared in these devastating times? Has it guided us through these bleak times and provided the yardstick and blueprint for all state actions? Has its performance matched its promise? Our learned speakers will address some of these issues. Besides the keynote address, we have 4 sessions to address the topics of, firstly, emergency and the Constitution; second, reform and revival of our parliamentary institution; third, the role of our constitutional monarchy; and fourth, a closing session by our distinguished retired judge and jurist, Tan Sri Zainun binti Ali. Our adjunct professor, Mr. Philip Koh, who was once a distinguished lecturer at our faculty, will be at the helm as a moderator in these sessions. Now, it is not my intention to preempt anything that the learned speakers may say, but as a student and lecturer of constitutional law, I can observe that at a theoretical level, the legal system of Malaysia exhibits all the marks of a developed and vibrant constitutional system. The 183 articles and 13 schedules in which the constitutional structure rests embody the following major characteristics: a written and supreme constitution, Islam as the religion of the federation, constitutional monarchy, parliamentary democracy, federal system, indigenous features of the Malay Peninsula, independent judiciary at the superior court level, judicial review of legislative and executive acts, fundamental rights, special powers against subversion and emergency, impartial public service, constitutional commissions, civilian control over the forces, legal pluralism, and common citizenship. The Constitution of Malaysia has survived for 64 years plus and has functioned well to preserve peace, stability, social harmony, and economic prosperity in an amazingly diverse nation. However, a wide gap has developed in the last 3 decades between constitutional theory and administrative and political reality. The Constitution has not become the force it was meant to be. There is lack of constitutional literacy and absence of constitutional patriotism within the civil service, the police, the politicians, and the citizenry. Constitutional supremacy is being eclipsed by many strong countertides. The courts often give full rein to legislative clauses that confer absolute powers, which are shielded by ouster clauses. Judicial review of parliamentary and state enactments on the ground of unconstitutionality is not an important feature of our constitutional reality. In theory, the Constitution is supreme. In practice, there is no dearth of laws that confer absolute powers on the executive. Fundamental rights in Part 2 of the Constitution were eclipsed by an emergency proclamation that lasted from 1964 to 2011, and then again in 2021. Though in 2021, fortunately, there was a sunset clause of about 6 months in the emergency proclamation. Parliament has struggled to emerge as the grand inquest of the nation. Despite the theory of responsible government, the executive continues to dominate. In general, many other check and balance institutions have struggled to enforce accountability, answerability, and responsibility. The federal state division of power is under scrutiny, especially in the peninsula's relationship with Sabah and Sarawak. Article 153 and affirmative action help the Malays and natives of Sabah and Sarawak a great deal to secure opportunities and for education and public sector jobs. But Article 153's implementations and operation is also under severe scrutiny. On a positive note, however, I have to say that with the spread of constitutional literacy, winds of change are blowing, and there is hope in the future for more constitutionalism, democracy, rule of law, and social justice. The Faculty of Law at University Malaya has always played an activist role in promoting activity of thought in many contentious areas of law and to point out issues where the law is ripe for review. Specifically in the area of constitutional literacy, we work with the Bar Council to organize periodic seminars and to produce a monthly Consti bulletin that is put together entirely by the talent and commitment of our wonderful students. Through the mass media, our staff and students take the Constitution to many homes and many hearts. We are very passionate about this role of ours. This seminar is a continuation of our effort to promote good governance and the rule of law through the knowledge in constitutionalism. Thank you, ladies and gentlemen, for joining us on this occasion. May what we do today contribute to the fulfillment of our role as a responsible faculty of law, and more so as we move into our golden jubilee year, which we shall be celebrating next year. Again, my thanks to all of you who have contributed in making this seminar a success. Thank you.
Thank you, Dekan, for that address. We appreciate the clarion call and the phrase that is used and has been used in globally among democratic nations, the commitment to the Constitution as a form of patriotism to the country. We're now very pleased to hear an address from Yang Berhormat Dr. Sri Azalina, and as the Dean mentioned, she is one of our alumni of the University of Malaya, and we are very proud to have her this morning to give us an address, which she has pre-recorded. She apologized that she cannot join us live, but this pre-recorded message is what we would listen to, and we welcome her address this morning.
Profesor Madya, Dr. Johan Shamsuddin, Dekan Fakulti Undang-Undang Universiti Malaya, penceramah terbilang Tan Sri Zainun binti Ali, Tan Sri Datuk Muhammad Arif bin Muhammad Yusof, Profesor Andrew Harding, Profesor Kevin Tan, Profesor Adjunct Philip Koh, Profesor Emeritus Datuk Dr. Shad Salim Faruqi, Miss Karen Chia, Encik Muhammad Nazim, dan para hadirin. I am privileged to be part of this seminar organized by my beloved alma mater, and I wish to congratulate to the Dean of the Law School, Datuk Johan, and his faculty members for organizing this thought-provoking event. I am aware that many other similar occasions have been arranged by your faculty for the public, and this reflects your diligence and activism to share such essential knowledge and understanding of law with people beyond university borders. We are all acutely aware that the law can never stand still. It takes learning, courage, and vision to highlight the need for growth and reform in the law. The deliberations of this seminar are immense interest to me and to the government I represent. Some of the topics like reform and revival of our parliamentary institution have been the subject of many efforts by myself. I believe that law reform contributes to the shaping of democracies to suit changing political and legal environments. Laws need to be reformed to adapt to the felt necessity of the times while adhering to well-accepted constitutional norms and principles like rule of law, separation of powers, and human rights. In addition, our goal for law reform should not be just to pass laws, but to make sure that the laws are practical, implementable, enforced equally and justly. Where there is disconnect between the law and the realities of human lives, there will be human rights violations. Your seminar topic, Does the Constitution Matter?, is intellectually provocative, and my answer, like yours, is that yes, of course, the Constitution matters, whether in settled conditions or in times of emergency. The Constitution is our basic law. It is our forefathers' master plan for our nation. It describes the manner in which the state is organized, government carried on, and justice administered. It creates the various organs of the state, describes and limits their powers and functions, and prescribes rules about their relationship with each other and with the citizen. At the political level, the Constitution concerns itself with the location of authority in the state. It tells us how to manage power and secure liberty. At the philosophical level, it supplies the fundamental or core values of which our society is funded. The experts you have recruited for this seminar will certainly throw light on the question whether a lacuna has developed between the theory of constitutional supremacy and the philosophical realities on the ground, and how this gap that also exists in all other legal systems can be reduced. I am sure that there are no simple answers. We have currents and cross currents in our legal system, and the constitutionalism picture is mixed. Any perspective is bound to be subjective. In my personal opinion, there has been a steady decline in the way constitutional principles are practiced in our beloved nation. While facing a global pandemic was unprecedented by governments and the administration across the globe, the government of the day then had boldly advised the king to promulgate an ordinance which effectively suspended Parliament for 6 months. Distinguished guests, ladies and gentlemen, this is indeed unprecedented because almost all other nations have not resorted to such extreme measures because they recognize what the Parliament signifies to the people. For example, the New Zealand Parliament adopted procedures to facilitate activities and committees. In Australia, the House of Representatives resolved to meet in a manner not provided under the standing orders in response to the pandemic, and so did the parliaments in Indonesia and France. The importance of the Malaysian Parliament can be best illustrated when we look no further than the Kedahan King's speech on the 12th of September 1959, as recorded in the handset, wherein His Majesty ruled that the Parliament is the very crown and climax of our Constitution, because the legislative authority of the Federation is vested in Parliament, which consists of the Yang di-Pertuan Agong and both houses purportedly representing the people. His Majesty further ruled that in this, the climax, because it is with the establishment of Parliament, the Constitution of our country is given full effect for the first time. Hence, I reiterate that our federal constitution should always be upheld at all times whether in settled conditions or in times of emergency. Other practical challenges that comes to my mind is the guarantee of equality and non-discrimination framed under our fundamental liberties. The women's rights movement have achieved many victories, but there remain many areas where the rays of justice have not yet been penetrated. The law comes face to face with prejudices and practices thousands of years, which is extremely biased. For instance, Article 40, bracket 1, bracket B, which poses great challenges to our very own Malaysian mothers who gives birth in foreign land, further prove the existence of practical challenges in achieving true gender equality, even with Article 8 of non-discrimination in place. The Constitution is a living instrument that must be periodically reviewed and kept alive in the ever-changing world. While we justifiably seek reform and change, we must at the same time count our blessings. These blessings are many. The Constitution has survived 64 years. The 58 or so amendments to the Constitution in 64 years were achieved in accordance with the procedures mandated by the Supreme Constitution. There have been no coup d'etat, no stern warnings by the armed forces. The army and the police have remained under civilian control. The Constitution has functioned fairly well to preserve peace and stability. No region, religion, or race is at war with the central government. The law and order situation is under control, and that itself is conducive to the flowering of other human rights. Before we were hit by COVID-19 devastation, we enjoyed one of the highest standards of living in Asia. Ladies and gentlemen, I am aware that similar to other societies, a wide gap exists between constitutional theory and administrative, economic, and political realities. Awareness of this gap is the first step towards resolving it. One of the major parts of the problem is that there is a lack of constitutional and legal literacy. Here is where law faculties can play a more vigorous and constructive role to aid the education system to promote constitutional literacy, to balance rights and responsibilities, and to teach respect for the rights of others. I wish to end by saying that I harbor the hope that on the solid constitutional foundation that exists, we can build institutions, principles, and procedures to strengthen constitutionalism and rule of law in our democracy. Despite the harsh challenges of COVID-19 crisis, the weakening of the economy and the loss of political stability at that time at the federal level since 2020, something we never saw before, let us hope that the imperatives of the Constitution will one day become the aspirations of the people. We all have a role to play. I wish the Faculty of Law to know that the windows of my mind and the doors to my office are always open to you and your constructive suggestions. Lastly, I congratulate Mr. Malaya, Faculty of Law, for being a leader in this field, and I wish you to enhance your efforts. Thank you so much. Wabitaufiq wa hidayah. Wassalamualaikum warahmatullahi wabarakatuh.
We'd like to record formally our appreciation for Datuk Seri, the Minister, who has taken out time to give us her message. The Dean, would you like to say something before we move on to the next program? Is there something you'd like to add?
No, I'm fine. I'd just like to record a thanks to YB Azalina for presenting that. And it presents a great opportunity for us as the faculty to provide input to the government in terms of changes in the be positive for the nation. Thank you very much.
Thank you so much. The Minister, who is now charged also with issues concerning Parliament, human rights, has opened up her doors of her mind and her physical doors. So we would attempt to knock on it gently or be invited one day to interface with her. In her speech, she has made known that the forum that we are now organizing is an initiative whereby the academia join hands with the private sector, the Malaysian Bar, which is represented through Ms. Karen Chia this morning too. And he has highlighted a number of key issues, of which some of them would be canvassed both this morning and on the Monday, or the 13th November, where another important topic will be taken up by two speakers in that day. But this morning itself, we have two major issues. One, when we ask the question, does the Constitution matter? We are asking a key question, especially in what we call a time of crisis or emergency. And that kickstart the first part of our program this morning. We are very pleased to have with us our Datuk Emeritus Professor, Dr. Shad Faruqi, who is no stranger in public discourse, and he is one of the voices that is regular for the last decades in both the media before there was social media and now with the social media. And he would contribute both not just his knowledge and experience, but we know he would communicate his passion and his wisdom in these issues, of which the first session, emergency and the Constitution. Over to you, Professor Dato' Shad Faruqi.
Thank you very much, Philip. May I say Assalamu alaikum rahmatullah, Salam Sejahtera to all participants. Good morning to the Dean, Dato' Associate Professor Dr. Johan Samshuddin, distinguished members of the panel, and ladies and gentlemen. I'm honored by this invitation. I am going to speak with you about emergency and the Constitution, and how the law seems to be evolving in this area. Whether the evolution is in the right direction or in the wrong direction will be a matter for further discussion and subjective opinions. May I begin by pointing out that our country has experienced 4 national emergencies, and there have been in addition 5 localized emergencies. May I request slides to be moved? Anyway, I'll continue. Now, the declaration of emergency anywhere in the world is a regrettable event because it involves the acquisition of exceptional powers by the government. I'm sure you will agree with me that whenever power is enhanced, liberty is necessarily subtracted. While this is true, what needs to be clarified is that there are many misconceptions about emergency rule that need clarification. Next. There is a popular but mistaken view that once emergency is proclaimed, the Constitution is suspended. Parliament is dissolved, cabinet is dismissed, elections are postponed, human rights are suspended, and the federal government automatically acquires the powers of the states. Actually, this is not true. A proclamation of emergency is a mere declaration. It does not prescribe any law. It does not automatically suspend. I emphasize automatically. It does not automatically suspend any law, any institution, or any procedure. However, it does open the gate to enactment of emergency acts by Parliament or emergency ordinances by the Yang di Pertuan Agong if the 2 houses are not in session concurrently. Next, as to the federal constitution, during an emergency, the constitution and ordinary laws are not automatically suspended, though they can be. However, any provisions eclipsed by the emergency law will revive 6 months after the emergency ceases. That's Article 150, Clause 7. This means that emergency laws can suspend but cannot amend the Constitution. On this point, I'm not on the same track with some of my other learned scholars from Singapore who have said that emergency power can be used to amend the Constitution. I do not believe that is correct. You can use emergency power to suspend the Constitution, but not to amend the Constitution. Then state constitutions, they are not automatically suspended. State executive remains intact unless suspended by an emergency federal law. Sabah and Sarawak's special autonomy remains intact unless an emergency ordinance provides otherwise. Civilian government. Next slide. Civilian government stays in place. The army does not take over. Curfew is not automatically declared. The cabinet remains in place unless an emergency law provides otherwise. Parliament is not automatically required to be sent off on prorogation or dissolution, though the federal government acquires the power to do so. It is required, in fact, by Article 150, Clause 3, that any proclamation and ordinance are to be laid before Parliament, and Parliament has the power to annul the emergency or annul the emergency ordinances. State assemblies are not automatically required to be sent off on prorogation or dissolution, though federal law acquires the power to do so. Please do bear in mind that we were under emergency for 47 years. During those emergency, elections were held. Parliament and the state assemblies continued to perform their functions. Next one, elections. An emergency does not automatically suspend elections. During the emergency era of 64 to 2011, 11 general elections were held and federal and state legislatures were elected. However, the emergency ordinance of 2021 sadly suspended the provision for general and state elections, and Parliament was totally marginalized. Human rights are not automatically rendered ineffective, though Parliament acquires the power to abridge them. The courts of the land remain in operation and are not replaced automatically by military courts. Habeas corpus, the writ of habeas corpus, is not suspended. All rights and privileges, all institutions and procedures remain in effect unless an emergency law explicitly says to the contrary. Substantive limits on emergency powers to legislate do exist. This is a controversial area, has not been litigated as yet. Under Article 150 Clause 6 and 150 Clause 6A, no emergency law can touch on matters of Islamic law, custom of the Malays, native law or custom in Sabah Sarawak, religion, all religions, citizenship, everyone's citizenship, language, everyone's language. So emergency law cannot, by a simple majority or by an ordinance, truncate powers or rights in these areas. There are some safeguards for preventive detainees under Article 151. Procedural rights are there. Then there's the provision for expiry of emergency laws. If emergency comes to an end, then Article 150 Clause 7 provides that emergency laws will cease to have effect after a grace period of 6 months, beginning with the date on which the proclamation of emergency ceases. So please bear in mind that though emergency was lifted on August 1, emergency laws, at least some of them, are still in operation till February, because 6 months will expire. Why do I say some of them? because some of the emergency laws or some of their provisions specifically say as long as the emergency lasts. So since emergency has ended, those provisions also have ended. Now, I come to the legal effects of an emergency. That is what is best known. One legal effect is there is a tremendous expansion of Parliament's legislative power. Once a proclamation of emergency is gazetted, the floodgates are lifted. That's not my voice, eh? Once emergency is gazetted, the floodgates are lifted and extraordinary legislative powers gush forth in abundance. The legislative authority, if Parliament is in session, becomes greatly widened. Parliament may violate fundamental rights, trespass on state powers, pass any laws by a simple majority. The consent of the Conference of Rulers and the governors of Sabah Sarawak is not needed. Parliament almost becomes supreme, except as to those 6 topics in Article 150, Clause 6A. Parliament actually becomes supreme, though we'll cover this point in greater detail later on. The king acquires parallel lawmaking powers. And on this point, our constitution has been amended in a very unhelpful, negative way. Previously, the law was that if Parliament is in session, the Yang di Pertonagong cannot promulgate ordinances. Now, the law says if the 2 houses are not sitting concurrently, and as you all know, the 2 houses never sit concurrently, or if at all, very, very rarely. So basically what it means is that during an emergency proclamation, we have 2 parallel law-making authorities. The country almost operates like a diarchy. Lawmaking power resides both in Parliament, if Parliament is in session, and in the Yang di Pertonagong, who has the same powers as Parliament to promulgate ordinances. As we all know, ordinances are promulgated outside of Parliament without the benefit of democratic discussion. Judicial review is excluded. So this is a point on which I'm sure the moderator will be raising issues later on. Judicial review on constitutional grounds become difficult, if not impossible, because of Article 150, Clause 6, which states that no provision of an emergency law shall be invalid on the ground of inconsistency with the Constitution. Article 150, Clause 8 explicitly bars judicial review. And I have to point this out to you. This 150, Clause 8 was not there in our Merdeka Constitution, which was drafted with much greater sense of constitutionalism. This came in actually after the government lost the Teh Cheng Po decision. Next. Federal-state relations can be affected while a proclamation is in force. The executive authority of the federation extends to any matter within the legislative authority of the state. Under Article 150, Clause 4, the federal government can give directions to the states or any of its officers, and the separation between the federal and the state executive can be ignored. It is clear, therefore, that emergency powers in Article 150 provide the basis for a special legal system that is parallel to and superior to the ordinary legal order established under the Constitution. Next, time limit. Emergency proclamations and emergency ordinances have no time limits, at least not at the present. But may I point out to you, before 1960, the law was more wholesome. A proclamation had a life of only 2 months. Proclamation means the proclamation of emergency, 2 months. An ordinance by the Yang di Pertonagong had a life of 15 days after both houses sat. I think we need to go back to this wholesome provision. Next, how can an emergency come to an end? There are four possible ways. First, if the proclamation contains a sunset clause, as the January 2021 proclamation did, then the emergency ends when the sands of time run out on the proclamation. And number two, the king acting on advice has the power to revoke an emergency. Third, Parliament may, by a simple resolution in both houses, annul the proclamation and annul any emergency ordinance. And fourth, all emergency laws expire 6 months after emergency ends. But the sad thing, and I think Professor Phillips was pointing this out earlier, though one emergency ends, that does not prevent the executive from issuing a new proclamation of emergency. Now I come to the role of the monarch. Next one. During an emergency, the king has two critical functions. First of all, to proclaim the emergency, he acts on advice. Secondly, to promulgate emergency ordinances if the two houses are not sitting concurrently, which they normally do not. But no law forbids the Dewan Rakyat and the Dewan Negara from meeting concurrently. Now, there is an animated debate about whether emergency powers are personal to the king or are exercisable on the advice of the Prime Minister. I will present both the law and the popular opinion to you on the point. Next one. Can the Yang di-Pertuan on his own initiative proclaim an emergency even if the Prime Minister does not so advise? Or can the Yang di-Pertuan refuse his Premier's counsel to proclaim an emergency, as happened in October 2020? Can the king say no to an emergency ordinance sent to him for signature? The reality here is this, Prof. Phillips, that the ordinances are framed by the Attorney General's office with no participation from the king. Then the Attorney General's office, on behalf of the government, transmits those ordinances to the king. And it is known that sometimes the king has virtually no time to examine these ordinances, to consult with anyone, and his signature is needed so that the ordinance can come into effect. So can the king say no to an ordinance sent to him for signature? Can he seek amendments to the ordinance submitted to him? I think these are questions that were raised during the last emergency. Is the king's exercise or non-exercise of emergency powers subject to a challenge in the courts? Now, there are two views. One view is that emergency powers are on advice. There's a long line of academic and judicial opinion that despite the subjective language of Article 150, Clause 1, the declaration of an emergency by the monarch is a non-discretionary power to be exercised on advice. This was also the opinion of the Reid Commission. In Madhavan Nair versus Government, Justice Chang Min-tat opined that emergency rule does not displace the king's position as a constitutional monarch bound by the Constitution to act at all times on the advice of the cabinet. Next, reference may also be made to similar opinions in a number of cases. The most famous is Tay Cheng Po. Then there is, of course, Abdul Ghani, Ali Ahmad 2001, and there are many other cases. In the light of the above cases, it is submitted that the proclamation of emergency by the king is not free of the constitutional requirement to act in accordance with the advice of the Prime Minister. Article 150, Clause 1, that bestows emergency powers on the king, must be read along with Article 40, Clause 1 and 40, Clause 1A, that impose a duty to act on advice. Next slide, please. Now, may I go to the second view, that the declaration of emergency is a royal discretion. May I point out to you, the law is what happens. At least in constitutional law, that is so. And therefore, we must take note of the realities on the ground. We must take note of public opinion. Though the courts may not cater to public opinion, may not, but sometimes they do. Article 150 states, if the Yang di Pertuan Agong is satisfied that a grave emergency exists whereby the security or the economic life or public order in the Federation or any part thereof is threatened, he may issue a proclamation of emergency, making therein a declaration to the effect. The law does not say, subject to Article 40, Clause 1. 40 Clause 1 is that the king, in the performance of his functions, must act on advice. So the law does not say, subject to Article 40 Clause 1, if the Yang di Pertuan Agong is satisfied. So a literal grammatical interpretation of Article 150 Clause 1 may lead to the belief that the proclamation of an emergency is within the sole discretion of the Yang di Pertuan Agong. This royalist interpretation can be supported by the following considerations. Number one, Article 40 Clause 2. It states that the Yang di Pertuan Agong may act in his discretion in the performance of the following functions, namely appointment of PM, dissolution of Parliament, convening of the Conference of Rulers, and in any other case mentioned in this Constitution. In any other case mentioned in this Constitution. To some commentators, the subjectively worded powers of His Majesty under Article 150 Clause 1 appear to fall nicely within the category of any other case mentioned in this Constitution. This is not my view. I don't agree with it. I think it should be any other case explicitly mentioned in the Constitution, explicitly. But this is the view of many royalists. Next one. Prime Minister Tunku Abdul Rahman's evidence in Madhavan Nair. The case is 75, but actually the evidence was given immediately after the 1969 emergency. When the Emergency Essential Powers Ordinance number 1 of 1969 was challenged on the ground that it was not promulgated by the Yang di Pertuan Agong because the Gazette notification lacked authentication. The then Prime Minister submitted in court, I personally presented the said ordinance to His Majesty for his consideration and approval. Having considered the said ordinance and being satisfied, His Majesty approved the promulgation of the said ordinance. So many people say the first Prime Minister, who was actually one of the forefathers of the Constitution, was of the view the king must be personally satisfied. Then next one, the next slide, the withdrawal of the 1983 amendment to Article 150. In 1983, the then Prime Minister Tun, Dr. Mahathir Mohamad, pushed through Parliament the Constitution Amendment Act 1983, which amended Article 150 Clause 1 to read, if the Prime Minister is satisfied that a grave emergency exists, he shall advise the Yang di Pertuan Agong accordingly, and the Yang di Pertuan Agong shall then issue a proclamation. Now, many people say, if the power always belonged to the PM and the king was bound by advice, why was there a need for this constitutional amendment in 1983? This amendment that was passed in the Dewan Rakyat and Dewan Negara elicited strong opposition from the Conference of Rulers and was consequently repealed in 1984. But its story firmly planted the seeds of belief that in times of emergency, the Yang di Pertuan Agong may act on his own without reference to the cabinet. I just want to submit this to you. Many people in my classrooms have argued, sometimes convincingly, they have argued that Article 40 Clause 1 applies to the rest of the Constitution, but Article 150, Clause 1 on emergency is a special portion, and 40 Clause 1 does not apply. Next one, in this case, Muhammad Amin, which was later on overturned on some of the issues by Abdul Ghani in 2001. But this was a groundbreaking case where the High Court held that if during the dissolution of Parliament there is no cabinet in existence to advise the monarch, then the king is empowered to issue a proclamation of emergency on his own. So the judge was suggesting that if during an emergency, if during the dissolution of Parliament, when elections are called, there is no cabinet, then the king can act on his own. Well, and then the judge also went on to say, and if there is a caretaker government in place, as there is in the interim period between dissolution and the election, the caretaker government's advice on national emergencies is not binding on the Yang di Pertonagong. That's what Muhammad Amin said. But as I mentioned to you, it was overruled. However, its view retains support among the royalists. Next, in October 2020, Tan Sri Muhyiddin Yassin advised the Yang di Pertonagong to proclaim an emergency, but the king refused. The rejection was not challenged in a court of law, and it sets a precedent of the throne supplying a check and balance to possible abuse of executive power by the cabinet. Then next one, creation of a parallel advisory body to the cabinet in 2021. The Emergency Ordinance of 14 January 2021 in Section 2 established an independent special committee to advise the king on the emergency. This looks similar to the Magiran appointed in 1969, and royalists ask, if the king is bound by cabinet advice during an emergency, then why was this independent committee appointed? Next slide. Number 7, summoning, prorogation and dissolution of state assemblies. The Emergency Essential Powers Ordinance 2021, sections 12, 14 and 15 lay down that federal parliament and state assemblies are suspended. Elections are postponed. However, section 15B and 13B say that state assemblies may be summoned, prorogued or dissolved. State election may be held on a date as the Yang di Pertonagong may deem appropriate after consultation with the respective ruler or the Yang di Pertonagiri. So something new was inserted in this ordinance of 2021. The rulers, the state rulers and the Yang di Pertonagiri were given a role in the emergency. Now, consultation with the rulers prior to the above decisions was a constitutional innovation, marking a heightened role for the state monarchs during the time of emergency. Then next one, summoning of parliament. During 2021 of Tan Sri Muhyiddin Yassin's tenure, parliament was not allowed to meet to perform its constitutional functions under Article 150 Clause 3. The king repeatedly asked the Prime Minister to advise the king to summon parliament. At the king's insistence, parliament was finally summoned to meet on 26 July, but only for 2 days. Number 8, revocation of emergency ordinances. 3 days before parliament was to meet on July 26th, I think. 3 days before parliament summoning on July 26th, the Prime Minister advised the king to revoke some of the emergency ordinances. This would have prevented parliament from scrutinizing them. Under Article 150 Clause 3, the king refused to revoke the ordinances on the ground that the job should be performed by parliament. The social media was abuzz with questions about whether the king can constitutionally refuse such advice. Slide 29. Now, in the light of the above, it is submitted. Professor Phillips, I'll just take 3 more minutes. In the light of the above, it is submitted that despite the king's general duty to act on advice, there are some circumstances in which the king may be legally justified in acting in his discretion. Number 1, if the prime minister lacks parliamentary legitimacy. For example, if parliament was dissolved for an election and the PM is a caretaker prime minister, or he's an interim prime minister, or if he has lost a vote of confidence, or he's facing a vote of confidence and wishes to declare emergency to avoid facing the House, or if he has lost his party leadership and he advises an emergency proclamation. I think in this situation, the king may well refuse advice because the prime minister who advises emergency must have parliamentary legitimacy. Number 2, if the government, next slide, 30, if the government abuses its emergency powers for wrongful purposes, a sagacious monarch may delay, caution and warn. Delay, caution and warn. Not refuse, but at least delay. He may refuse to issue the proclamation, and his refusal cannot be reviewed by the courts because of Article 150 Clause 8. Now that's a interesting issue. Article 150 Clause 8 was basically meant to prevent citizens from challenging an emergency. But what if the king refuses and the prime minister takes the king to the courts? I think Article 150 Clause 8 will cut both ways. Number 4, if the PM presents an ordinance to the king which violates Article 150 Clause 6A. I mentioned to you the 6 sacred topics in 150 Clause 6A. Is the king bound to sign an ordinance which is clearly violating Article 150 Clause 6A? The king may justifiably refuse. Number 5, if the PM requests the king to revoke ordinances just a few days before Parliament is supposed to meet, the king may be justified. It's questionable, but may be justified, and he may advise the PM to let Parliament scrutinize the ordinances first, as happened to Tan Sri Muhyiddin Yassin. Now I'll stop here because I've run out of time. I was going to cover role of the rulers, role of Parliament, role of the courts. I'll let Karen Chia, my learned colleague from the bar, take over. Maybe I can handle these during question time. Thank you very much, Professor Phillips.
Thank you, Professor Shad, for your very able presentation of the frame background of what this colloquium is about, in particular of recent proclamation of emergency. And you have highlighted very provocatively the issue of what we call a royalist interpretation and the contestation between Article 40 and Article 150, this relationship of the language of mandatory and also the issue of YDPA satisfaction and the issue of refusal, that one event. These issues throw up fascinating trajectories for our discourse, which will continue through to Monday. But now we are very happy to have Miss Karen Chia, a very committed member of the Malaysian Bar and serving in the Malaysian Bar Council in the Subcommittee on Human Rights, which also deal with Constitution, of course. Miss Karen Chia will come on board to share from, in some ways, of course, her personal point of view, not Malaysian Bar Councils as such, but her contribution to this discourse is going to be much of value. I personally know Miss Karen Chia, and we are very, very privileged indeed that this morning she is coming here to share a point of view also in this very lively discourse. Miss Chia, over to you.
You are mute.
Can you, yeah.
Yeah, sorry. Thank you very much for your kind introduction, Philip. Good morning to everyone, professors, ladies and gentlemen. It's a privilege and honor for me to be talking about this particular topic today. I think Professor Shad has touched very much on the powers of the parliament and the powers of the monarch insofar as what transpired during the 2021 emergency period. I'd like to take us away from the role of the parliament and the role of the monarch and see, the role of the judiciary, how the judiciary has a role to play insofar as the emergency period is concerned. Raymond, could I just have my slides up? Thanks, Raymond. Right, so moving on to the next slide. So, when we talk about the role of the judiciary and the implications of the emergency of proclamation and the courts, one cannot stay away from Article 1508 of the Federal Constitution. And we know Article 1508 of the Constitution actually provides that, if the king is satisfied that a proclamation of emergency is to be made or ordinances are to be promulgated, then that satisfaction or that exercise of power by the king shall be final and conclusive. And shall not be challenged or called into question in any court on any ground. And it goes on further to say that no court shall have jurisdiction to entertain or determine any application, question, or proceeding in whatever form on any ground regarding the validity of the proclamation or the declaration made, the continued operation of such a proclamation, any ordinance promulgated under Clause 2, capital B, and the continuation in force of any such ordinance. So Article 1508 clearly states, that, it's an ouster clause. It ousts the role of the judiciary when it comes to the emergency proclamation and the promulgation of emergency ordinances. Next slide. So Professor Shad did touch briefly that Article 1508 was not initially there when the Constitution was drawn up. Historically, Article 1508 was inserted by the Constitution Amendment Act of 1981 through Section 15D, and this came into force on 15th of May 1981. Prior to the insertion of this ouster clause, the question of whether the validity of a proclamation of emergency was justiciable was actually quite unsettled. And we start off with a couple of cases. Back in 1968, the case of Stephen Kalung Ningkan against the government of Malaysia, the federal court decision by way of a majority judgment ruled that the circumstances which brought about the state of emergency are non-justiciable. But however, at the Privy Council level, Lord McDermott ruled that the issue of justiciability raised by the government of Malaysia led to a difference of opinion in the federal court, and whether a proclamation under statutory powers by the supreme head of the federation can be challenged before the courts on some or any grounds is a constitutional question of far-reaching importance, which on the present state of authorities remain unsettled and debatable. So back in 1968, we see a situation where, there is a state of conundrum where the issue of justiciability of Article 150 is concerned. Now, the Privy Council did not really answer this question and left it to be dealt with in future proceedings, and therefore the common law discourse by the courts were therefore necessary on this point. Next slide. And everyone talks about the case of Teh Cheng Po against public prosecutor when it comes to, whether or not the proclamation of emergency is a justiciable issue. And in this case, their lordships had actually decided at the Privy Council level, when one finds in the Constitution itself or in a federal law powers conferred upon the Yang di-Pertuan Agong that are expressed to be exercisable if he is of the opinion or is satisfied that a particular state of affairs exists or that particular action is necessary, the reference to his opinion or satisfaction is in reality a reference to the collective opinion or satisfaction of the members of the cabinet, or the opinion or satisfaction of a particular minister to whom the cabinet have delegated their authority to give advice upon the matter in question. And in this case, the Privy Council opined that the judiciary has the jurisdiction to inquire whether the purported exercise of the discretion was actually ultra vires. So Professor Shah did say that it is by virtue of the government of Malaysia losing the case of Teh Cheng Poh that the ouster clause under Article 1508 of the Federal Constitution was actually inserted into our Constitution. So when we do talk about the historical perspective and also the framework of our federal constitution, we cannot run away but to refer to the basic structure that's contained within our constitutional framework. It is embedded in the federal constitution, the doctrine of separation of powers, and that the basic structure of our governmental system is divided into three branches, and we all know this: the legislative, the executive, and also the judiciary, all of which are placed as a check and balance of each other's function and powers. And the separation of powers therefore form that basic structure of our constitutional framework. In view of this, that role of judiciary in the check and balance mechanism then becomes very, very crucial. It is a cardinal principle of law that the judiciary is the ultimate interpreter of the federal constitution, and hence the guardian to ensure that the executive and the legislature act within their constitutional limits. Where the exercise of powers by the executive and the legislature is ultra vires or wrong in law, it is therefore the duty of the courts to intervene by way of a judicial review as enshrined within Article 4(1) of the Federal Constitution. In the case of Lim Jen Sian against Ketua Pengarah Jabatan Pendaftaran Negara, the Court of Appeal encountered an ouster clause in Section 2, Part 3 of the second schedule of the Federal Constitution, whereby it provides that a decision of the federal government on citizenship shall not be subject to appeal or review in any court. The Court of Appeal held in this case that such an ouster provision does not preclude the jurisdiction of the court from entertaining a judicial review application. Next, I will also be going through in some of the recent cases that's been decided by the courts insofar as ouster clauses are concerned, and the role of the judiciary in coming up with such important and significant decisions. The federal court's decision in Maria Chin Abdullah against Ketua Pengarah Immigration recognized that the presence of ouster clauses would never deter the court from examining any dispute or complaint that is referred to the court. The court is entitled to examine, evaluate, and assess the exercise of power. In light of this, the judiciary should have the judicial power to hear any challenge brought before the court. Now, although the majority decision of the federal court case in Maria Chin Abdullah held a different view on the application of the doctrine of basic structure, our Chief Justice said, and albeit in minority, the supremacy of the federal constitution in Article 4(1) and its corollary device of judicial power are basic features of federal constitution. And so accordingly, the power of the court to scrutinize state action, whether legislative, executive, or otherwise, cannot be excluded. And this view is also substantiated by the apex court decisions in Semenye Jaya and also in Indira Gandhi, where the apex courts reaffirmed the principle that judicial power resides with the judiciary. In the next slide, I have highlighted the two significant cases of Semenye Jaya and Indira Gandhi. And I think that this paragraph, which has been quoted by the Federal Court Judge Zainun Ali, is very crucial to us. In this case, she noted that inherent in these foundational principles in Westminster's constitutions is the role of the judiciary as the ultimate arbiter of the lawfulness of state action. The power of the courts is a natural and necessary corollary of the rule of law. In many jurisdictions, this was made clear. In Malaysia, in the seminal decision of the Federal Court in Pengarah Tanah and Galian Wilayah Persekutuan against Sri Lempa Enterprise, Raja Azlan Shah, Chief Justice, or as His Royal Highness then was, expressed in a passage which has remained inviolable that unfettered discretion is a contradiction in terms. Every legal power must have legal limits. Otherwise, there is dictatorship. In particular, it is a stringent requirement that a discretion should be exercised for a proper purpose, and that it should not be exercised unreasonably. So in other words, every discretion cannot be free from legal restraint. Where it is wrongly exercised, it becomes the duty of the court to intervene. The courts are the only defense of the liberty of the subject against departmental aggression. So in both the Semeni Jaya and Indira case, these to me form very good precedents for the courts not to take Article 1508 at face value, and that the constitutional principles require the courts to continue engaging in the interpretation and the validity of that Article 150 sub 8. So that's the premise that I'm laying down in terms of how we should be approaching and interpreting Article 1508. And then when we look at some of the approaches in the UK, and I'll call this the Ennis Minnick approach in the UK. In the case of Ennis Minnick against Foreign Compensation Commission, we see that the English courts' approach is that they are growing increasingly averse to giving effect to ouster clauses within the country. And this is what they say. If they reach a wrong conclusion as to the width of their powers, the court must be able to correct that. Not because the tribunal has made an error of law, but because as a result of making an error of law, they've dealt with and based their decision on a matter with which, on a true construction of their powers, they had no right to deal with. If they base their decisions on some matter which is not prescribed for their adjudication, they are doing something which they have no right to do. And if the view which I expressed earlier is right, then their decision is a nullity. And the other case, Privacy International, also a case from the UK, basically says the same thing. Basically, they're just saying that the powers exercised by the executive and the legislature should be subject to scrutiny and subject to judicial review. I'll just skip this. I want to go to the next slide. So when we've been talking about the historical aspect of how Article 150 came about and the jurisprudence of cases in Malaysia and how it applies to our 2021 period of emergency, let's have a look at the Proclamation of Emergency that was actually declared and took effect from the 11th of January to the 1st of August 2021. So the King issued a proclamation of emergency. And the Emergency Essential Powers Ordinance of 2021 was also promulgated and coming into operation on the same date. So when we look at the Declaration of Emergency, as well as the ordinance that was promulgated, we note that there's several provisions within the emergency ordinance which are particularly concerning. One is the suspension of the federal and state legislative proceedings, and this is contained in sections 14 and 15 of the ordinance. There is also a suspension of the federal and state elections. We also saw the entrenchment of the position of the then executive at federal and state levels. We saw vast powers of the armed forces being given, and also vast powers to temporarily take possession of land, building, or movable property, and also assessment of compensation cannot be challenged by the courts, another ouster clause within the emergency ordinance. And there is also a general immunity provision within the emergency ordinance, shielding the government from any acts that have been taken during the emergency period. So these were some of the worrying provisions contained in that emergency ordinance, which of course did not go through the parliamentary process. Next. So because of those worrying concerns, in Malaysia, we saw 6 suits being filed challenging the emergency proclamation, and I've listed those 6 suits there. The first one is by 7 non-governmental organizations, Bersih, Suaram, Center of Independent Journalism, Aliran, Kuala Lumpur and Selangor Chinese Assembly Hall, Gerak, and Safe Rivers. And within this particular suit, there were 5 interveners, Khairul Nizam bin Khairuddin, Ahmad Fadli bin Shari, Muhammad Apandi Muhammad, Yusmadi Muhammad Yusof, and Shamsul Iskandar bin Muhammad Akin from Melaka. Then we have a second suit, which is by Hassan bin Abdul Karim. I think he's the MP for Pasir Gudang. And we also have a third suit by Datuk Sri Salahuddin Ayub, Datuk Johari bin Abdul, and Abdul Aziz bin Bari. The fourth suit is by Datuk Sri Anwar bin Ibrahim. The fifth suit by Khairuddin bin Abu Hassan. And the sixth suit, which has just been filed, is a suit that was filed by the Malaysian Bar recently, a few months ago. So what is the status of these 6 suits? So far, we have seen in the case of Hassan bin Abdul Karim, the at-leave application for judicial review has been dismissed at High Court and the Court of Appeal. I think this just happened a couple of weeks ago at the Court of Appeal level. Same thing for Datuk Sri Salahuddin Ayub's case. The leave for application for judicial review has been dismissed at High Court and also the Court of Appeal. And the third case by Datuk Sri Anwar Ibrahim, also dismissed at the High Court and Court of Appeal. All these 3 cases, the decision by the Court of Appeal were delivered, I think, at the same time. The fourth suit by Khairuddin Hassan, the originating summons was struck out at High Court, but I understand from the counsel who's actually handling the matter, and he's just confirmed that with me yesterday, that the case is pending appeal to the Court of Appeal and it has not been disposed of, and hearing will be fixed later. So there are 2 other cases which is still pending and have not been disposed of, which is the suit by the 7 NGOs and also the suit by the Malaysian Bar. So there are still live issues in so far as the issues that have come up from the emergency proclamation. And I think that we should not give up hope yet that the interpretation of Article 1508 may be seen favorably by some of the courts, in the future. I want to just look at the failed challenges under those 3 suits. Now, in those 3 suits, those issues that were posed to the court were in respect of the validity of the decision of the then Muhyiddin-led cabinet to advise the Yang di-Pertuangan Agong to promulgate Section 14 of the Emergency Essential Powers of Ordinance 2021, which then resulted in the suspension of Parliament and asking a declaration that it is unconstitutional and unlawful. However, the 3 high courts gave unfavorable rulings to the legal action to all the 3 suits. The High Court had actually agreed with the submission from the Attorney General's chambers that Article 1506 and Article 1508 of the Federal Constitution ousted the courts from having jurisdiction to hear legal challenges to the Yang di-Pertuan Agong's proclamation of emergency and challenges made against the YDPA's emergency proclamation and the ordinances enacted. And that therefore, these questions which were posed to the High Court was not amenable to judicial review. And they went further on to say that Article 1508 was valid and constitutional. Now, I have mentioned it earlier on that there are still several suits which is still live issues before the court and have not been ruled by the courts yet. So I'm just going to pose some of the issues that have been posed by the Malaysian Bar to the court for the court's decision. Now, all in all, there are 27 constitutional questions posed to the High Court to be considered in its challenge on the validity of the emergency proclamation and the emergency ordinance. But I've picked out a few of what I think are the crucial constitutional questions posed. Firstly, whether Article 150 of the Federal Constitution is unconstitutional in permitting by the enactments of the emergency ordinances, the suspension of Parliament, and the removal of all executive accountability, and is therefore inimical to a democratic government and in contravention of the basic structure of the Federal Constitution. So it is a very broad question of the interpretation of Article 150 itself. And then the next question that was posed by the Malaysian Bar to the courts, whether Articles 1506 and 1508 of the Federal Constitution are unconstitutional as being inconsistent with Articles 4(1) and 1211 of the Federal Constitution and the basic structure of the Federal Constitution, and are therefore null and void and of no legal effect. The other three issues posed were whether Articles 1506 and 8 of the Federal Constitution are unconstitutional as being inconsistent with Articles 4, 5, 8, 121 of the Federal Constitution, and therefore null and void and of no legal effect. Whether pursuant to Article 1503, the first defendant and or the second defendant are under a constitutional duty to forthwith advise the Yang di-Pertuan Agong to summon a meeting of Parliament for the proclamation of emergency and emergency ordinances to be laid before both houses of Parliament and for all necessary and appropriate resolutions to be passed. And the other issue that I've picked out was there are also other issues relating to the powers and the process of the revocation of the proclamation of emergency and emergency ordinances that have been posed to the High Court, and that's all contained in the application for leave for judicial review by the Malaysian Bar. Now, insofar as the 7 NGOs challenge in their suit, they have raised 4 main issues to be posed to the court. The first one being, given that both houses of Parliament had not been dissolved but only stood adjourned at the relevant times, whether the proclamation of emergency issued on January 11, 2021, promulgated on January 14, 2021, had to be laid before both houses of Parliament pursuant to Article 1503 of the Federal Constitution. The second question that they posed, whether Section 14 of the Emergency Essential Powers Ordinance 2021 relating to the suspension of Parliament is valid insofar as it prevents or frustrates the operation of Article 1503 of the Federal Constitution. And in brackets, Section 14 purports to, inter alia, disable the operation of the provisions of the Federal Constitution relating to the summoning, prorogation, and dissolution of Parliament, and to cancel any meeting of Parliament that had been summoned but not yet held. And I've actually highlighted the third and the fourth question because I think those questions are very important. The third question is whether the 1981 constitutional amendment that added Article 1508 of the Federal Constitution that purportedly ousts the jurisdiction of the courts is unconstitutional for violating Articles 4 and 121 of the Federal Constitution and or the basic structure of the Federal Constitution. And the last question that was posed by the NGOs were whether Article 1508 of the Federal Constitution, even if valid, prevents the courts from reviewing the constitutionality of an ordinance made under Article 150 to capital B that does not comply with or prevents or frustrates the requirements of Article 1503 of the Federal Constitution, which require the proclamation and ordinance to be laid before both houses of Parliament. So those are, crucial issues which have been posed by the Malaysian Bar and the 7 NGOs to the court. We are still waiting for the hearing date to be fixed. It's not been fixed so far. So hopefully, keep following the news and hopefully, keep advocating that this Article 1508 is something that should be decided on the validity and the constitutional basis. Next slide. So I am going to just conclude here that the Constitution and the role of judiciary in an emergency is absolutely important. I mean, there is no way that the judiciary can wash their hands off and say, this is no longer our concern, mainly because there exists Article 1508 of the Federal Constitution. Let us not forget, one of the things that I mentioned earlier on was that the interpretation of the Federal Constitution is something which falls squarely within the purview of the judiciary, and it should be an obligation that the judiciary must undertake. So the fundamental principle of constitutional supremacy embedding the doctrine of the rule of law can only be maintained and achieved through judicial participation and intervention in interpreting the constitutional provisions, which are regarded as a deterrent to the spirit of constitutionalism and rule of law. The Malaysian courts play a critical role in ensuring that the legality of legislation and actions of executives can be challenged on grounds of accountability and constitutionality. Unfettered powers to one arm of the Federation undermines our constitutional rights and people's fundamental freedoms. And there must be judicial resistance against the court's powers of review being ousted through legislation. While such provisions may exist, it is ultimately up to the courts to determine their constitutional limits and validity on the basis of the rule of law. And this is very crucial in the interest of the nation and the spirit of our federal constitution. So I'm just going to end here to say that, I think there has got to be some advocacy on the introduction of ouster clauses in our constitution, which we see is becoming more and more prevalent. Not only in the constitution, but we also see ouster clauses coming in a lot of legislation. At last count, I was looking at approximately 70 to 80 legislation with ouster clauses, making those powers exercised by the executive non-justiciable or not subject to judicial review. So, this is something that we have to continue knocking on the door and making sure that it does not eat into the space of our judiciary's role. Thank you.
Thank you, Ms. Chia, for a very able update, especially from the perspective of the role of the civil society and the Malaysian Bar in the attempt to safeguard the proper scope of the provisions of our federal constitution. I would like to urge all participants to also, as we listen in, to have a look at the chat box, and you are invited to type your comments, either for everyone to see or to direct it to anyone particular if you prefer your message to be private. There has been some exchanges and some comments at the chat box. You're very much welcome. I would like to, I know we are pushing on for time, but this is a very, in a way, this session sets the framing of many of the sessions, all right, including the one that will follow right after this. And on Monday, the role of constitutional monarchy. And though we don't have a separate topic on judicial power, this has been highlighted both by Professor Shad and also Ms. Karen Chia. I would like now to invite the registered participants to raise questions. If you'd like to raise up your hand, I could recognize you. You could even orally pose the question or a comment. Try to keep it brief, but it will be, I would like to give some time for this before we invite the next session on board. Does anyone need to make a comment or remark or question, or Shad to kickstart? Would you like to respond? Or maybe, okay, Majid has put up his hand. Maybe we invite Dr. Majid, who teachers at the Sunway, and now in kind of a quasi-retirement. I would call quasi because nobody retire, right? We don't retire. We just have to continue until we lose our appeal lawyers, all right? Dr. Majid, over to you.
Thank you, Philip. I'm going to be a bit historical and personal.
Go ahead quickly.
I'm going to focus on the rights conferred upon the citizen, part 2 of the Constitution. From the very beginning of our history, the internal security, first there were the Emergency Regulations 1948, which were then revived or resurrected as the Internal Security Act 1957. Now, throughout our history, the courts have been more or less subservient to the executive when it comes to legislation eroding the rights of the citizen. So this is where I become personal. When I was much younger, I lived in the Philippines, and then I spent 19 years in Hong Kong. Let me talk about the Hong Kong experience. I was in Hong Kong when it was a British colony, and then it was a part of a communist state after 1997. My experience was that as a colony and as a part of a communist state, Hong Kong then had more freedom, personal freedom, than we ever had as an independent country. And one thing that I realized in Hong Kong was that unlike us, here we have rules which say that if you want to have a demonstration or protest, you get permission from the police. My impression of the Hong Kong procedure was that it was different. There, the police were under a duty to protect the protesters, so that if they turned down your application, they had to give a reason related to their inability to control the counter-protesters. And on occasion, when the police were there and protesters were attacked, they actually seized the protester and put her, this is her, into a van and took her away for her own safety. So I think what is not appreciated in Malaysia is that the authorities have a duty to safeguard the rights of the citizen. They don't not only have to worry about controlling the citizens, but they have a duty to create the situation in which the rights of the citizen can be exercised.
Yes.
So I think that is something that's missing in our setup. And this is because we more or less came out of the emergency. We didn't come out. We had an emergency, then we had emergency, and then we had the annulment of the emergency, followed by the Internal Security Act, which was just a continuation of emergency regulations. So all the way through, as different speakers have pointed out, we were subject to this mindset. And the fact that these are rights that the executive must protect for us has never been made.
Interesting, Dr. Majid. Any comments from our two speakers? Shad, maybe I invite you, whether the issue of not just the human rights, but a reciprocal obligation of regulatory and enforcement agencies to be cognizant of protective of such rights while ensuring law and order. Any comments from you, Shad? Unmute, please. Thank you.
Yes, yeah, thank you. I totally agree with Dr. Abdul Majid that the police, the civil service, local authorities exist, first of all, to enforce the law, and secondly, of course, to serve the public. They are not there simply to tyrannize or terrorize the citizens. I think in every democratic society, there must be a balance between the might of the state and the rights of the citizens. And I think Dr. Abdul Majid has hit the nail on the head by saying that mindset is still the mindset of emergency powers or absolute powers. However, on a small matter, I just wanted to tell Dr. Majid that under the Police Act, section, was it 26 or 27, Karen, maybe you could help me. Under the Police Act, yes, one had to get permission from the OCPD to hold an assembly or a procession. But under the Peaceful Assemblies Act, the law has changed. Dr. Abdul Majid. Now there is no requirement to get prior permission. All that is required now is to give them a notice that we are going to meet. The notice period at one time was 10 days, and I think the period has now been reduced to 5. So what you were recommending actually is the spirit of the Peaceful Assemblies Act. The police are there as facilitators, not as those who should obstruct. But the mentality of the police officer is still the mentality of the Police Act, Section 27, Clause 5, whereby they say, oh, you didn't get prior permission. Whenever I read that statement from the police, oh, XYZ didn't get prior permission, I tell myself, this police officer needs to read the latest law on the point. So I think the mentality is wrong. This raises the broader issue of legal literacy, broader issue of constitutional literacy. And I think that's what this seminar is about. That's what the University of Malaya has been trying to do. And I'm in agreement with you that ultimately constitutionalism, human rights, rule of law, unless they have a place in our hearts, they have no place anywhere else.
Thank you, Chad, for that sterling call. Karen, any quick comments? Quick take? If you would like to add any comments? Unmute, please.
Thanks. Just wanted to add, I think it was Section 27 of the Police Act, if I'm not mistaken, Prof. Shah.
Yeah, yes.
And you are right. There is no need for any police permit. But you know, after more than 10 years of the Peaceful Assembly Act being implemented in Malaysia, the police are still talking about a police permit under the Police Act. Yeah. So you know, this creation of awareness within our not just the citizens, but also within the sphere of the authorities is something which has got to continue again.
Well, Karen, your reminder jogged my memory that during the time of our protests in the university years ago, Gudel Singh confronted the FRU with the Constitution, and he was told, well, put that away, you know, I'm going to throw you into the Black Maria, right? And you might get a crack on the skull. So much for waving the Constitution in front of an enforcement officer. But anyway, that's anecdotal. Karen, you want to round up your comment?
Yeah, I do agree with Dr. Abdul Majid and also Professor Shad. I think the actions of our authorities sometimes may show that, you know, that they are actually bullying the citizens rather than they are facilitating and serving the public. In this period, when we go through when we face some of these authorities who are trying to enforce the laws, you find that there are a lot more friendlier party authorities rather than the unfriendlier ones. So that's my experience insofar as that is concerned.
Thank you. We are running a bit of a short time. A very brief concluding observation. I would like to afford that to first, Karen, since you were just speaking, maybe you say something in closing, and then Shad, and then we can close up this session.
I don't have very many things to add, actually. I think that we should keep our eyes and ears out on the development of the jurisprudence on Article 1508. I think that's very interesting. Keep abreast with the cases going on with the Malaysian Bar and the 7 NGOs. That should be something that we must continue to look at. Thank you.
Okay. Well, I've just been reminded, although I'm the moderator, that actually we have extra minutes, but yeah, we can move the discussion forward. And even both of you, if you are staying on, when Kevin and Arif give their piece on Parliament, we can still join in the conversations. I look at these sessions as not silos in themselves, but there are intertextual, intersubjective constitutional issues that we can have a discourse on. But Shad, would you like to say something?
Yes, I don't know if you'll permit me so much time. I need to make two comments. First of all, I'm fascinated by Karen's presentation on the possibilities of judicial review and how it could be grounded in some of our case law. I just wanted to add to that the court may possibly follow the recent British decision in R. Miller versus the PM and Cherry versus Advocate, where the British Apex Court said, we are not challenging the Queen's prorogation of Parliament. We are examining the good faith or bad faith of the Prime Minister's advice to the Queen. So the Prime Minister was trying to avoid or evade scrutiny in Parliament by proroguing Parliament, and the court said that that is in bad faith. So I feel that the court may follow in relation to 150 clause 8. Perhaps our court could follow the Miller decision, where the thrust of the argument will be this, Prof. Phillips, that while the courts may not question the monarch in the light of Teh Chang Po and many other decisions, the court may question the PM's advice to the monarch if it is in bad faith. So that's one point I wanted to make. Secondly, there was a question on the net here just now about how I have tried to interpret, or I don't know whether it's interpret or misinterpret, the powers of the Yang di Pertuan or lack of powers under Article 150 Clause 1. Actually, I'll summarize my views. I think our Constitution created a constitutional monarchy. The King is bound by the advice of the PM in the exercise of his powers under the Constitution and laws. However, I have to say this, the Prime Minister whose advice is binding must be a Prime Minister who possesses democratic parliamentary legitimacy. If it is a Prime Minister who is a caretaker Prime Minister, when you are a caretaker Prime Minister, there is no parliament at that time. You have no majority. Parliament has been dissolved. You are there basically to hold the fort. You are as in cricket, you are the night watchman. You are just holding the wicket. So if in such a situation the Prime Minister advises emergency, I think the King may well say, wait till elections are completed and then we will look into the matter. Or if the Prime Minister has lost a vote of no confidence, instead of resigning, he says, I advise you to declare emergency. So I think that's the situation. The Prime Minister has the right to advise the King. The King is bound by advice, but if it is a Prime Minister who has legitimacy, this issue of legitimacy is quite a broad question. The exceptions I would provide to this is, I'll take just half a minute more, Prof. Phillips. Exceptions are this. In some articles of the Constitution, it is explicitly mentioned that the King may act in his discretion. For example, in the appointment of the governors of the states, the 8th schedule specifically says the King in his discretion, after consulting with the Chief Minister or Mantri Besar. It is in his discretion. There are many other areas, appointment of the JPA, Jabatan Perkhidmatan Awam, Education Service Commission, and a few other areas, but explicitly discretion is mentioned. Secondly, there are some areas where by necessary implication, the King has discretion. For example, under Article 66, Clause 4, capital A, the King can delay by 30 days. Now, surely in delaying by 30 days, he doesn't act on the advice of the Prime Minister. It is an implied discretion. That's all I wanted to say. Thank you very much, sir.
Thank you, Shad. I also see a very senior practitioner posing a question on the chat box. Shan, would you like to pose it orally? I think it's worthwhile since I now realize I do have a few more leeway in before the next session. Shamuga, would you like to articulate it for everyone? Shan, are you there? Well, Shan posed the question very interestingly. As a senior practitioner in this field on judicial review, responding to Dr. Majid, he observed that most of the cases cited, all right, also Shad has, Faruqi has helpfully put most of those cases out, other than, of course, the current cases of update of our challenge, are cases of national security issues. And even in England, national security issues tend to put a lot of pressure, not pressure, thus is given some priority by the courts in exercising some reticence about a review of the executive decision. However, when we deal with constitutional norms and conventions, and Shad has so helpfully raised a phrase, a legitimacy, all right? The whole issue that governs constitutional discourse is the legitimacy of rule practices and rule interpretation. This is extremely important, all right? And therefore, we need to realize that both political actors, PDRM, enforcement agencies, governance administrators, be it either at the federal, state, or even local government, or other entities, need to understand that unless their actions are governed by rule respect, not both the substance, the text, and that they're acting with objective clarity for the public good, there will be deep questions raised about the legitimacy of the action. We are probing much more further issues in this particular phrasing, and obviously we can't unpack all of it in a session like this. Professor Shad has also helpfully pointed out that the Federal Constitution, we are now shading into Monday session in some ways, all right? The royal constitutional monarch role, there are clear discretion. We have chosen that word carefully. Prof. Shad has also done so. Sometimes in public discourse, the word used is royal prerogative. And then words like durhaka is thrown around, all right? Now, for legal jurists like us, we are careful about such words. But nonetheless, the social scientists in some of us would say these nomenclature has powerful symbolic appeal and need to be brought into the discourse, not so much juristically, but recognizing that in our country, though we are maturing towards a mature democratic society, these nomenclature has power to persuade both populist sentiments and perhaps even in some instance, judicial perspective in interpreting the federal constitution. We are now deeper into interpretive issues, and we can't unpack all that obviously in a session like this. So that's my very brief response to short, very helpful rounding out comments. We are now happy to move towards the next session, and I see my good friend and my former lecturer, the respected Tan Sri Arif Yusof, when both he and the late Azmi Khalid and Dato Sri Hisham Mudin Yunus and my good friend Wan Hulaimi came back from LSE, and we were in the third batch of the law school. Their impact to the ethos of University of Malaya is now seen, all right, even we hope during this current administration and also the judiciary. We're very, very happy that today he is willing to spend some time to share his insights for us, because as Dato Sri Azalina and our Dean has said, we are talking not just about personal agency and political actors, we are looking at institutions. And the debate between, in Commonwealth country, of parliament sovereignty, constitutional supremacy is found converged this morning in the next session. But before I do so, I want to record once again my gratitude and thanks to Professor Shad Faruqi, Ms. Karen Chia for ably steering us towards the opening session. And as we move towards the second now, I'm very happy to hand over the next session on issues of parliamentary reform in institutional issues, where we will be joined by my good friend Kevin Tan from Singapore, who could also lend his views to us, just as Dr. Majid have lent his views coming from Hong Kong. We now welcome Tan Sri Arif Yusof to give us his learned comments and insights. Over to you, Arif.
Thank you very much, Philip. It's always a pleasure to be part of a law faculty sponsored event. Thank you for inviting me to present my views on the second segment of this webinar, Reform and Revival of our Parliamentary Institution. The general topic of this webinar, does the Constitution matter, is obviously very thought-provoking and timely, given the present circumstances. Does the Constitution matter, particularly during times of crisis? As someone who has dealt with the Constitution of Malaysia for years on end, and who have fought some cases, I lost most of them. Of course, to me, the Constitution matters, even in times of crisis. But if I were to wear the hat of the ordinary Malaysian in the street, who has seen and experienced exceptional circumstances and developments in this country in the period between 2018 to 2020, and continuing, would it seem that the Constitution matters really? It is a point worth considering. If not, how can this perception be changed? So some of the issues that I will be dealing with revolves around this topic. Yeah. But I think it is useful also to remind ourselves of how is it that we have come to where we are. So a little bit of general background will be good, particularly since I suppose we have outsiders also participating. Let me just give a brief rundown of what exactly happened. As nearly most of us will know, on the 9th of May 2018, Malaysians voted in droves for a change of government in the 14th general election. The Election Commission actually registered a total voter turnout of 82.32%, a very, very high percentage by Malaysian standards. The federal government under the Barisan Nasional Administration and its predecessor, the Parti Perikatan, held the realm of political power for over 6 years. Suddenly, Barisan Nasional was defeated by a democratic choice peacefully expressed. So we had this beacon of hope in Malaysia and in the region. I had many friends and foreigners telling me when I was elected as a speaker, they were looking at the changes in Malaysia as a beacon of hope for the region, because elsewhere in the region, except Singapore has always been very stable. Before my friend Kevin butts in and say, no, I'll exclude Singapore, but other countries in the region were not faring that well. Yeah? But we were there. We showed the way that it is possible to effect a change in government by peaceful means. No demonstrations, no blood spill, nothing, no potted plants upset, nothing. So it was very peaceful. And people were very happy to have been given that opportunity to exercise the vote. Now, there's a catch to this. Although the Pakatan Harapan and its allies were returned to power, they were returned with less than 50% of the votes. 48.3% to be exact, for those who can remember. It had nonetheless a comfortable majority in the Dewan Rakyat, holding 123 seats out of the 222 seats in the Dewan Rakyat. The number, in fact, increased to 139 by April 2019. There's an irony here, because there were defections from UMNO MPs to Bersatu, a component party of the Pakatan Harapan coalition then. It was just short of 9 votes at one time to attain a 2/3 majority in the House. The result of party hopping, party defections. I've got a lot to say on this in a moment. Right? In the meantime, the Dewan Negara was still dominated by senators from Barisan Nasional and its allies. But that was not such a big problem. It was good actually in terms of development of the parliamentary system. We have the lower house being dominated by a different party from the upper house. It has happened in many countries, in Australia notably. We see such consequences happening, but that's okay. It is healthy for the democratic system. Now, in what has become known as the Sheraton move, I do not know who coined the term, but I've been asking around, no one seems to know. It just sprang and it was sketchy, and until today, we refer to it as the Sheraton move. The fortunes reversed. Within less than a week, at the beginning of February 2020, there were defections of a majority of MPs from Bersatu, including 11 defections from PKR, Parti Keadilan Rakyat. The Pakatan Harapan coalition thereupon lost its majority in the Dewan Rakyat. Tun Mahathir submitted his resignation and the resignation of the cabinet under Article 43, Clause 4 of the Federal Constitution, and was made the interim Prime Minister before the appointment of the new Prime Minister. The constitutional position of the Yang di-Pertuan Agong and His Majesty's role in the appointment of the Prime Minister, and the acceptable rules and principles surrounding the exercise of His Majesty's discretion were pushed to the fore. It also brought into bold relief the parameters of caretaker government in a situation outside the normal, where caretaker government is formed after the dissolution of the legislature. In the case of the appointment of the interim Prime Minister in the aftermath of the defections in the Dewan Rakyat, the caretaker government in place had to be redefined. What were exactly the powers and functions of Tun Mahathir as the interim Prime Minister? These are heavy constitutional issues, but the answers are hardly clear, I will submit. Take the case of the Malacca state election we just ended. The fall of the Pakatan Harapan government had repercussions at the level of the state legislatures. Melaka, Johor, Perak, Kedah, and Sabah fell as a result of defections. In Melaka, here I'm talking about the first fall in Melaka. In Melaka, there were 2 falls. The first fall in Melaka. The chief minister had to resign, but was not reappointed as an interim chief minister, pending the appointment of the new chief minister. The executive functions of the state were devolved to the state secretary instead of the chief minister to head the caretaker government. In the most recent development, Melaka 2, second fall, however, the loss of majority confidence in the legislature led to the Yang di-Pertuan Negeri exercising his discretion to dissolve the assembly, instead appointing the outgoing chief minister as the interim chief minister to hold office in a caretaker capacity until the outcome of the election. The case was brought in this connection just to follow up on the discussion on the emergency legislation, and we lost the case again on a very narrow construction of judicial function. The recent Melaka state election is also noteworthy as a mirror probably of what the Malaysian electorate can expect to see in the next general election. Barisan Nasional managed to secure only 38% of the popular vote, with Pakatan Nasional achieving only 24%. Pakatan Harapan, on the other hand, obtained 35% of the popular vote. Arising from the fragmentation of the popular vote and the effect of the first past the post system, Barisan Nasional won more than 2/3 of the seats, namely 21 of the 28 seats in the Melaka State Legislative Assembly. Pakatan Harapan won 5, while whilst Pakatan Nasional secured only just 2 seats. Very interesting outcome, really. Voter turnout was a disappointingly low 65.85%. In the 2018 general election and the state election in Malacca, the turnout, as I suggested earlier, was more than 80%. So you're looking at a very big drop. Now, what do these indicators tell us? The phenomenon of party defections, the Sheraton move, and the COVID pandemic have resulted in political and constitutional consequences, which have been until today unprecedented. All said, the party defections have led to instability. At the federal level, Malaysia has had 3 prime ministers since 2018. And it seems the current administration has managed to attain some level of stability because of the consensus it has agreed with the main opposition party, still back to Pakatan Harapan, through the signing of the aptly called Memorandum of Understanding on Political Transformation and Stability, something that jives with the current topic. Yeah. Unusual, a lot of commentators were talking in terms not of a Memorandum of Understanding on Political Transformation and Stability, but more in terms of the usual agreement on confidence and supply. But it turned out to be a different kind of creation here. There is, at least on paper, a recognition that there has to exist a common ground that stability and reform has to be undertaken. In the language of the defined scope of this part of the seminar, issues of revival and reform of the parliamentary institution should matter a great deal. And so I think it must have been in the minds of those who drafted the Memorandum of Understanding that we have to look seriously at parliamentary reform. But I've said on paper, there is a recognition. We have to wait and see whether the grand design will see the light of day. And soon, many a times in Malaysia, we've had grand designs, had high hopes. Hopes have been raised only to flounder for lack of political will. So, the immediate problem that has led to so much instability is no doubt, to my mind, the contemptible culture of party defections, or party hopping, or party frogging, whatever we would like to call it, and the consequent effects of backdoor governments being formed. Not only at the federal level now, but at state levels too. One after another, we see this instability. The grouse felt by many that it may be pointless to exercise their right to vote if the government that had secured the majority vote can be so easily displaced by MPs or state assemblymen defecting. Is of serious concern. Hence, I posed the question earlier, does it really matter to the ordinary Malaysian in the street? To some of them, the question keeps cropping up. What's the point? I come back from overseas, I rush back from another state to my home state, I voted, we won. How come it has come to naught? Does the Constitution really matter? Now, although one cannot be sure in the absence of concrete data, this feeling of being let down by the constitutional system could be a major reason for the low voter turnout in the recent Malacca state election. And also we have to factor in the reluctance to appear at the voting station for fear of the still present COVID-19 epidemic. In this regard, I now descend to a little bit of laws. What is happening in Malaysia today is a lesson, a very valuable lesson, on how a narrow approach to constitutional interpretation by the courts can have unfortunate consequences. I'm referring to the decision of the federal court here in Dewan Undangan Negeri Kelantan versus Nordin Saleh, 1992, 1 MLJ 697. A very well-trodden case, often cited not only for the exact results, but for the laudable outline or elaboration of the principles of constitutional interpretation. Everyone cites it. But I don't think this is a very good decision at the end of the day. Yeah? You parrot the lyrics, but the song is bad. Yeah? In this case, an anti-hopping enactment passed by the Kelantan Dewan Undangan Negeri was struck down as unconstitutional under Article 10 Clause 1, Paragraph C, which relates to the fundamental right to form associations. You're not talking about directly freedom of expression or speech, but this is in relation to the fundamental right to form associations. By deciding that, a state assemblyman or a legislator has a constitutional right to hop from one political party to another under the fundamental freedom of association, the court actually opened the floodgates to the culture of party hopping in Malaysia, which used to be limited to state legislatures. But in February 2020, that culture led to dramatic fall from power of the federal Pakatan Harapan government. The Pakatan National Government, as a backdoor government which succeeded it, became unstable too. There's a lesson here, and fell in 2021, arising from a withdrawal of support from several members from UMNO.
What's going on? I'm just putting it in the background. Oh, what happened to that?
It is high time, I believe, to propose seriously that amendments be made to Article 10, Clause 2, Paragraph C. It could take the following form. I don't know whether the slide actually arrived. Yeah. So I'll just read it and I'll perhaps post it later. Article 10, Clause 2, Paragraph C, for example, could be simply amended by inserting the provision in relation to restrictions, the following words: to protect the privileges of Parliament or any legislative assembly. The words, or to provide for disqualification of members of Parliament or members of any legislative assembly by any law relating to political party defections, and so forth. You can fine-tune the exact wording, but it should be added. And Article 48 on disqualification for membership of Parliament, excuse me, could also include an express disqualifying provision. For instance, under new paragraph AA, having been elected as a member of Parliament, as a political party candidate or as an independent, he resigns or is expelled or joins another political party other than the party for which he was elected. Or if he is an independent member, he ceases to be such an independent member. So we close all the loopholes so that party hopping becomes unconstitutional. And if the law provides that someone who party hops loses his election, we will not have another Nordin Saleh. Of course, presently, some commentators have proposed an alternative solution. That alternative solution is to enact an ordinary law on recall elections. But recall elections is unfamiliar territory for Malaysia, and I have my personal views on this. Even if you pass ordinary law on recall elections, you will still need to amend the constitution because Nordin Saleh still lurks in the background. Yeah? So I would suggest, therefore, given the Nordin Saleh decision, it may also be necessary to put the recall elections law in place to amend Article 10, Clause 2 again, to include an express mention of any law relating to recall elections. As of now, I think it is fair to observe that many Malaysians are still unfamiliar with the entire concept of recall elections, let alone understand how recall elections are to be organized. Unfortunately, the private members' bill on this, said to be introduced by our Deputy Speaker, Dr. Azalina, was not tabled during this current meeting of the Dewan Rakyat. That's ending soon. The momentum to effect a very necessary reform was not carried with immediacy. I think this is not a good start to the hopes and aspirations expressed in the MOU. I mean, this is familiar story, right? A proposal is made, there is delay, it's not stable. I do not know. I mean, this is something that we have to look at it very seriously as citizens of this country. We have identified the scourge, I would like to believe, behind the perennial political instability in Malaysia. But our politicians sadly seem reluctant to provide the cure fast. At an earlier webinar this year, I think the Deputy Speaker, Azalina, was also at the webinar. I offered my view that it might be better to start by having the constitutional amendments to Article 10 first. A law on recall elections can come later and cover a larger scope than just party defections. If the delay is caused by desire, perhaps, so I hear, to amalgamate or combine the two concepts of party hopping and recall elections, I would suggest be prepared for all kinds of delays and obfuscations. It has happened before. I'll be happy to be proven wrong. Yeah? It's now still being discussed, but let's wait and see. Now, what is the recall election? A recall election or recall election law allows for a kind of limited referendum. This is what it is, essentially, in certain defined situations, whereby the electorate can petition for the vacating of the office of a legislator, MP or state assemblyman, and have a by-election done. The by-election does not follow as a matter of course, obviously. Most jurisdictions will set a defined threshold, a petition by not less than 10% or 20% of the electorate for that particular constituency. This might pose a problem given the political maturity in Malaysia. The exact electoral process varies from jurisdiction to jurisdiction. It can get to be very technical. I don't propose to get into all the technicalities, which we did in the previous seminar. But we will leave it at that. And maybe there could be questions to be taken later on. It can get to be very technical. Who's to conduct the recall election? Who's to activate the recall election? What happens to the MP who defects? Can he recontest? That sort of questions, all of which will have to be answered. Frankly, I don't think the country can wait any further. Let us have a constitutional amendment to reverse the decision in Ordinance and stem the tide of political frogging. This is a fundamental problem that causes and perpetuates the instability that we see today in Malaysia. This is a constitutional hurdle that needs to be settled. The experience in the Penang Legislature in 2020 illustrates it well. You know, Penang amended its state constitution in 2012 to insert Article 14A, Clause 1, to address this problem. But the DUN could not pass the necessary motion to declare the seats of 4 of the state assemblymen who changed parties vacant, because they took action in the courts for a restraining order to prevent the tabling of the necessary motion on the ground that the purported amendment was invalid, based again on Article 10, Clause 1, Paragraph C of the Federal Constitution. So you see, Nordin Saleh comes back again, despite Penang passing that anti-hopping law. So nothing could be done. The motions were withdrawn. Once the cause for the instability is removed, I think this is properly amend Article 10, Clause 1, C. Once that cause is removed, the other institutional reforms relating to Parliament and the state legislature can then be undertaken in a more conducive atmosphere. It's not to say that there have not been reform processes undertaken previously. There have been. But once you allow party defections beyond control, this is what you get. Let me cite one glaring example. Before the advent of the unprecedented changes in February 2020, the parliamentary reform agenda had begun. And one of the main items was to reintroduce a parliamentary service where the Parliament of Malaysia would be given greater autonomy and kept separate from the executive. it was proposed that a parliamentary commission be established with its own independent board and administration, and to have administrative and financial autonomy. A draft bill was even prepared, but currently its fate remains unknown. I do not know what happened because I was instrumental in having the draft, the first draft, at this first final draft, you can say, done after so many years, but it's somewhere out there. And yesterday, there was again some talk of it being part of the reform agenda. Wait and see again. Valuable time, likewise, has been lost in the activation of the Parliamentary Select Committee system as a necessary component to actualize one of the primary functions of the legislature, namely to ensure executive accountability to Parliament and to oversee the proper use of national finances. The tumultuous events in 2020 have also shown the urgent need for wider reform in the parliamentary institution to ensure that Parliament can perform its designated role under the Federal Constitution so that public trust in the institution can be restored and enhanced. Some of these have been mentioned in the MOU. These include implementing the minimum voting age of 18 years old and automatic voter registration, for which the necessary constitutional amendments have in fact been put in place since 2019. To prevent excessive centralization of power and the cult of personality, Bosco and all that, time limits on the Prime Minister's post would be necessary, just as important as a reset of the current parliamentary culture with its excessive toxicity that can be seen more than once, no more than occasionally. A code of conduct to further bind the MPs to good parliamentary behavior with effective punishments and penalties is long overdue. It gives me no pleasure to further add that the code of behavior must also extend to the office of the Speaker and the Deputy Speakers. The culture of independence, fairness, integrity, and statesmanship must be nurtured so that Parliament can regain its rightful place as an august and responsible representative assembly. The suspension of Parliament by emergency decree last year, until very recently, on account of an essentially public health emergency, did much damage to the institution. This ties up with the earlier discussion on the emergency. I think it did much damage to the institution of Parliament. The perception of the public was lowered even further when MPs were barred from entering the grounds of Parliament thereafter, despite the yearly motions carried and directed to the Inspector General of Police that the roads to Parliament must be kept open and access to the precinct of Parliament facilitated. I would strongly suggest also that the standing orders be revamped to augment the powers of the Speaker and reduce the influence of the Prime Minister and the Minister in charge of parliamentary affairs to dispel the idea that Parliament is just an extension of the executive. It is undesirable to have the Prime Minister as the leader of the House. It is not a necessary imperative. Many parliaments operate well without this rule, but not in Malaysia. People think, the system will go haywire without this rule. Clarity is required to address such issues as opposition time, motions of specific and urgent matters of public importance, and the much vexed motions of confidence and no confidence. Equal constituency funding for all without discrimination, laws to control political funding, and tighter disclosure of assets ruled by MPs, and instituting a proper system of shadow cabinet should also be included in the reset of the parliamentary system. May I now end on this note and answer the question posed? Yes, the Constitution matters, and we should compel our elected representatives and our leaders to reflect and respect its first principles with statesmanship and a full respect for the underlying principles of the Constitution. Reform of Parliament is sorely needed. I don't think anyone in his right mind will say it is not needed, given our current situation. It is sorely needed. Without reforming Parliament, I'm afraid there will be little hope to regain the ever-elusive trust of the Rakyat in their elected representatives. They got to face facts. things are not hunky-dory. There's a great deal of reluctance on the part of some segments of the electorate in this regard. People keep asking, what's wrong with our parliament? What's wrong with our MPs? What's wrong with our leaders? People become very disappointed. They have lost the trust in Parliament as a primary institution, and that will be very sad if it is allowed to perpetuate. So something must be done. So I'm very thankful that we have the opportunity in such a seminar as this to vent all these issues. Maybe some people will disagree with me, but I'm hoping for those in the middle ground who will agree, I think. Those on the extremities can shout and protest, whatever, but we must look at the middle ground in order to proceed further. So with that, I end my segment, and we can take questions later if there are any. Thank you.
Thank you, Tan Sri, for a very interesting sharing from your own journey, the last 2 years or more, of your observation, both as a jurist, former judge, and speaker of our august house. Your insights, which interface law, political perceptions, reflecting the people's interests, and the lament and anxiety that you have that undergirds your sharing about trust deficit. We all have these issues, and your discourse has enabled us to have a handle to begin our conversation. So can we now invite Kevin, and then after that we will look through the chat box on those who may raise their hands. I would also ask the administrator to mute everybody. Unless you raise your hands, you will be immediately unmuted, and also you will be able to share. All right. The next speaker is a good friend in the legal and constitutional fraternity from Singapore, the institution of NUS. Professor Kevin Tan is a committed public lawyer commentator. He has taken part in commentaries, treatises, and also case books on constitutionalism, both in Singapore, Malaysia, and Asian constitutionalism. With that backdrop, we are very happy that this morning he's going to share with us his take on the issue of the institution of the lower house, the parliament. And perhaps even as he shared, he could slightly interface, if he cares to, what Tan Sri Arif Yusof may have observed in passing. Sometimes an outsider is able to see more because he's not himself in the aquarium where we are all swimming. So Kevin, over to you.
Thank you so much, Philip, for organizing this and for inviting me to come along to be among good friends to discuss this topic. Actually, as Shad was speaking just now and Arif was speaking just now, there was a sense of deja vu because the last time I was invited some years ago to speak in Malaysia, I was told at the last minute that I wasn't allowed to speak because I was a foreign speaker and that no police permit had actually been obtained for that particular occasion. So in a way, I think the poor organizers didn't get their money's worth. I was there in the audience, and actually Tommy Thomas substituted for me and actually spoke from the stage in my place. So it's really really interesting that now with Zoom, I don't suppose you need any kind of a permit of any sort. So I'm glad to be able to share some ideas with you. So with that, maybe I will share. I've got some slides, so let me share my screen so that I can take us through the various points that I'm going to make this morning. So the topic for today is, does the Constitution matter? I think that's a rhetorical question. Obviously, it does. What lessons have we drawn from the Malaysian Constitution in this period of crisis? And we're probably talking about the last 2 years. And the subtopic for this particular session is reform and revival of our parliamentary institution. So I have a couple of points to make, and I will end up with something which dovetails with Arif Yusuf's presentation just now, with a critique on the Nordin Saleh case. But before we talk about what we need to change, we might perhaps it might be useful for us to go back to basic principles and ask ourselves, what are the basic functions of Parliament? And well, I suppose you could probably give a long list of functions of Parliament, but I think most people would agree that when we talk about what Parliament is supposed to do, we talk about first the purpose of democratic representation. There is this idea that Parliament should have members who actually represent significant constituencies, right? Secondly, there's of course the legislating function, which is to make law. Third, the oversight of executive action. The Parliament makes the law, the executive merely execute it. And finally, of course, general debates over national policy. So if we bear in mind these outstanding functions of Parliament, let us take a look at three possible areas where reform is possible. Of course, as an academic, it's very easy to talk about reform because we don't have to get it done. I mean, somebody else has got to get it done. So what areas I think we can be looking at? First of all, I think major changes need to be made on the parliamentary processes itself. Secondly, something that has not yet cropped up in this morning's discussion, but is very much a part of this big debate, ongoing debates about representation in Malaysia, which is the malapportionment problem, gerrymandering and malapportionment, as well as representation. And finally, of course, I want to come to this topic of anti-hopping laws because it is, probably the most topical thing right now, given this pending private members bill before Parliament. Well, not quite before Parliament yet, but a pending bill. So let's talk first about the parliamentary processes, right? First of all, in order for Parliament to do its job, I think Parliament has to meet. And one of the big problems was in the last 2 years we have seen, and has been alluded to by all the speakers in this forum, that Parliament was not able to sit, notwithstanding the various efforts of parliamentarians and so on. Of course, we need to understand the constitutional provisions which facilitate Parliament meeting. And here the Constitution, like many constitutions based on the Westminster system, merely provide for some basics. So under Article 55, for example, it states that the Yang di-Pertuan Agong shall from time to time summon Parliament and shall not allow 6 months to elapse between the last sitting in one session and the date appointed for the first meeting in the next session. We also know that this is not a personal discretion on the part of the Yang di-Pertuan Agong, because Article 40 of the Federal Constitution states that the Yang di-Pertuan Agong must always act on the advice of the Cabinet. So in this way, what happens is that you have, in effect, given the Prime Minister and the Cabinet ultimate power to decide when a session of Parliament begins and when it ends, and more starkly, which is revealed in the proceedings in the last 2 years, is the relative interval between each meeting within a session. So we know the Constitution is very clear, right? States that between sessions, one session and another session, no more than 6 months can elapse. In other words, the Constitution mandates that you have to summon Parliament within that time frame. Otherwise, you'd be acting illegally. Parliament would not be if it were not summoned. However, we don't have any definition as to the gap between meetings within one session. So at the end of one session, what happens? You end up proroguing Parliament, and then you know that okay, the next time you start, it will be a brand new session. But what if you don't? What if you simply adjourn the session, adjourn the meeting, and then not fix it for another period? In other words, your session has not quite ended, and there is no date given. Can this extend beyond the 6-month period between sessions? I think if one were to sort of read these provisions purposefully, then it might be. I think it's quite clear that Parliament is not meant to be suspended indefinitely, and that nobody should be able to take advantage of the lack of a definition between meetings to stretch the gap of each meeting and adjourn something sine die. Basically, at infinitum without a definite date somewhere down the future. So if we look at what has transpired in the last few months, you can see, and I'll take you through this slowly. I'm sorry, it's a bit of a mess, but a lot of things have happened, as everybody knows. So we know that starting from the 24th of February 2020, Tun Mahathir resigns as Prime Minister, and he requests for a special session of Parliament. In fact, it is my co-panelist, Tan Sri Arif Yusof, who was the speaker who rejected Tun's request for a special session of Parliament on the ground, correctly, that summoning of Parliament must be from the Yang di-Pertuan Agong. In the meantime, on the 29th of February, the King appoints Muhyiddin Yassin as the Prime Minister. He's sworn in on the 1st of March. So theoretically, once you have kind of a change of government, Parliament should sit, as soon as possible. However, on the 4th of March, Muhyiddin actually delays the opening of Parliament for at least 2 more months till the 18th of May. Now, in the interim, quite a number of things happen, right? COVID-19 hits, there's a national lockdown, and on the 18th of May, the much awaited 18th of May, when Parliament was supposed to resume, it unfortunately resumed only for a royal address for half a day, and then is postponed again. So what is happening now is that you've got a summoning of Parliament, but Parliament actually doesn't transact any legislative business. In the meantime, you replace the Speaker. This is a world's first. It is unprecedented. Nobody has ever seen a Speaker being replaced in midstream. Your new Speaker only comes in after a general election. So it is by way of election in the Dewan Rakyat, but here you actually had a vote in the House, a bare majority of 2, replacing the Speaker with a new Speaker of the government's choice. Prime Minister, and this was alluded to by Shad in his presentation earlier, the Prime Minister proposes a state of emergency to the King on the 23rd of October, and the King says, well, there's no need for emergency. And here it is actually quite interesting. One wonders what would have happened if there was in fact a constitutional challenge in court. On the 16th of December, an emergency is promulgated first for two territories within Perak and in Sabah, and then a national emergency is promulgated on the 11th of January 2021. and there is one of the emergency ordinances also postpones the conduct of state and federal elections. So if you look at this particular period from, a lot has actually happened, something which I think ought to have been debated by parliamentarians has not been done because Parliament simply doesn't sit, right? So anyhow, you have the first emergency ordinance on the 25th of February, and then the drama begins again with party hopping. UMNO withdraws its support for Muhyiddin on 7th of July. And finally, on the 26th of July, Parliament reopens for 5-day sitting, ostensibly to debate, right? Because you need to present the emergency ordinances before the House. And I think for fear of a motion of no confidence, the law minister declares that all the emergency ordinances have already been revoked, and there was therefore no need to have them on discussion. Muhyiddin resigns on the 16th of August, and 5 days later, his successor, Ismail Sabri, is appointed Prime Minister. And finally, on the 25th of October, Parliament repeals emergency ordinances, and finally, after the pact between the parties, Parliament finally reconvenes. So you see, with all these events, the dysfunction of Parliament during this period. This is not how Parliament is supposed to function. If you have an emergency, the Constitution is very clear. Upon the proclamation of emergency, you shall summon Parliament as soon as is practicable. But here, it seemed as if it was the executive branch making it not practicable for the summoning of Parliament whatsoever. So I'll leave that at that, and I think some other commentators have already remarked on this, and I'm sure Tan Sri Arif has much to say about how this thing can be remedied. The second point I want to address is the problem of malapportionment of electoral divisions. This is something that has been discussed, quite a fair bit over the years already, and I just want to go through, some salient aspects of this. The opportunity to malapportion arose really as a consequence of a bargain that was struck prior to Merdeka. In fact, in the lead up to the 1955 general election for the Federation of Malaya in 1953, Nodal McIlvery, this guy you see here, he was the Deputy High Commissioner for Britain. He proposed proportional representation system in Malaysia to ensure that you have a fair representation not only of the majority, but also of the minority ethnic groups within the country. This was rejected outright because it was thought to be far too complicated for a polity like Malaya to be deployed. So in 1954, a commission known as the Merthyr Commission on Constitutional Delineation was established, and they considered various options. One of the options, in fact, in the terms of the reference of this particular commission, they were asked to consider whether or not multi-member constituencies might, in fact, be used in Malaysia. This is really a fascinating fact. I think in Singapore, everybody thought that the group representation constituency or the GRC system, which is a multi-member constituent system, was a fairly new innovation when it was put forth in 1988. Actually, this had already been considered but rejected by the Merthyr Commission in 1954. And instead, they were in favor of a single-member first-past-the-post system of voting. Now, the other thing which is very important, and this is where things got awry, additional weightage was given to the rural constituencies, mainly because back then in the 1950s, it was very difficult to get connected with the rural communities. And so it was meant as a temporary measure whereby you would give greater weightage to the rural constituencies, and the variation that was allowed was up to 35%. In other words, you could have, if you do a calculation, your largest constituency could be 3 times larger than the smallest one. Like many provisions in the Merdeka Constitution, this idea, or at least the system of voting, was meant to be temporary because, communications do not stagnate, forever. When things improve, when you have greater access to rural parts of the country, you're not supposed to just merrily keep this going. But anyway, not only did the government keep this going, they augmented this. So 1955 election, this was the great election which the Alliance won. The voting population, as a consequence of citizenship laws and so on, at that point in time, was overwhelmingly Malay. So there was 84% Malay voters, 11% Chinese, and 5% Indians, right? And so the Malay voters outnumbered non-Malay voters in 50 of the 52 constituencies. So you had a clean sweep in that case, right? Quite simply, if you simply pandered to the Malay vote, right? Now, as Malaysia inched towards Merdeka 1956, there was the Reid Commission. They recommended, what they thought would be a good system for Malaysia. They wanted a 3-member election commission that was independent and impartial, a constitutional body not reporting either to Parliament or to the Prime Minister, and with the remit that delimitation of boundaries should be as far as practicable, such that every vote is of equal value. So they realized the problem of the Merthyr Commission. They understood that there was this 35% deviation, but the Election Commission at every review was supposed to ensure that, as far as possible, you try to balance it. So if you can bring it down from 3 to 1 to, 2 to 1, that would be much better, right? Rather than and kind of increase that. Now, the Election Commission that was established under the Merdeka Constitution actually adopted a 15% variation above or below the average constituency size, which is actually, the move in the right direction, or at least in the intended direction that the Reid Commission had in mind for elections. And in 1959, now things began to change, because in 1959, although the Alliance again won, not as thumpingly as they did in 55, they won 73 out of 100 seats, but the percentage of votes had dropped to 51.5% as opposed to like 80% in the 55 election. And so this was the point when I think the tinkering began. In 1962, UMNO abandoned the 15% limitation, decided to revert to 35% limit under the Merthyr Commission. And in 1973, the constitutional limit on the rural weightage was completely removed. Now, nobody remembers why the rural constituencies were given more, or rather were larger than or had higher number of weightage than non-rural voters. So what happens now is, of course, you see the disparity. If you look at the table here, 59, the ratio, as I said, was about 3 times, went up to 4.43 times in 69. By 74, after they abandoned the rural weightage limitation, it went up to 5.61, 6.66. And then somehow it came down in 2004, went up again in 2013, and in 2018, it went to a staggering 9.10 ratio. In other words, the difference between the smallest constituency and the largest constituency. And the poor guys in the largest constituency, your vote counted only for 1/9 the vote of those who came from the smallest constituency. So you see this problem of malapportionment, which defeats one of the fundamental functions of parliament, which is representation. How can it be that certain groups of people, right, or smaller groups have more representation than those who live in larger groups, right? Obviously, this is all done together with redrawing of electoral boundaries and so on, in order to favor particular constituencies and parties insofar as the vote is concerned, right? So this is something that needs to be looked at seriously. There is no reason why we can't go back to what the Reid Commission proposed, to have a 15% deviation, given that we are now living in the 21st century and the kinds of handicaps that should have been that warranted the rural weightage, I think need now to be reconsidered very, very seriously. Finally, we come to this topic of the anti-hopping laws, which Tan Sri Ariff has already alluded to and spoken quite a fair bit about. The relevant constitutional provision is, of course, Article 48(1) of the Federal Constitution, which stipulates 6 grounds for disqualification from membership in Parliament. However, none of these grounds includes loss of membership or deprivation or change in a member's party membership, right? So that means, right, the real effect, of course, is that when a member of any political party ceases to be a member of that party under which he or she was elected, and you might cease to be a member whether because you resign or you were dismissed or you were removed somehow, this member will continue to keep this parliamentary seat, okay? Now, this, of course, there are a couple of problems with this proposition, right? First of all, in terms of pure representational theory, right? What does this member who has resigned from this particular political party and maybe chosen to be neutral and independent, or join another political party, who or what does this member represent, right? So this is from a purely theoretical perspective. And I think in many Westminster style constitutions today, we don't take the sort of the Burkean, the Edmund Burke idea that you elect somebody because this person is thought to be, I don't know, a paragon of virtue, somebody you think who is the best person to represent your interests in Parliament. Instead, what people vote for are parties with ideologies, with platforms, and so on. So if you see, so if you got into Parliament by dint of the fact that you were flying a particular party's flag, then having now lost that membership, no longer being a member, then obviously you cannot be said to be representing your constituencies based on any particular party platform. Worse still, if you switch over to the other side, whatever other side that was, which you had opposed, you are now actually going completely against the voters' ideas of who you are and what you represent. So this is sort of purely on an abstract theoretical level. But on a practical level, as Tan Sri Ariff has pointed out, this has caused so much trouble. And yes, it used to be a state government problem. I don't know whether I got all the dates right here, but I after a while I kind of lost count, especially with Sabah. Here, what happened was, every time you have a defection, then the government collapses, you have a new government, you end up having a new chief minister or Menteri Besar being appointed. And it started early, 62 with Terengganu, then Sarawak in 66, the famous Stephen Kalong Ningkan case, then Kelantan in 77, then the first of the Sabah. I think Sabah, there are 3, 94, 2018, and then 2020. Perak, the famous one, where actually, I think Tan Sri Ariff, you were the High Court judge in that case. I seem to recall. And of course in 2020, a whole slew of these state defection problems, right? Sabah, Perak, Johor, Melaka, Kedah. Up to 2020, only a state problem, so to speak. But then in 2020, you had this at the federal level. And of course, that led to the toppling of the federal government, first with Mahathir and then with Muhyiddin. Bottom line is, this makes for a very unstable form of government. And so the question is, why can't we simply adopt so-called anti-hopping laws? In some countries, they call it anti-defection laws, but I prefer anti-hopping because anti-defection seems to suggest that, for some reason, the party needs to hang on to you for some reason, right? No, you should have a free choice. You can choose to leave your party, of course. So anyway, with anti-hopping laws, why can't it be changed? And everybody knows and mentioned the Nordin Saleh case. The main sticking point has always been whether or not Article 10(1)(c) of the Federal Constitution is somehow violated if you put in an anti-hopping law. The rights embodied in Article 10(1) are derogable rights, right? I mean, in the Constitution, there are non-derogable rights which are absolute, right? The right to equality is non-derogable, for example. Rights against slavery are non-derogable, but rights of your udri public rights, your right to free speech, to assembly and association, those are derogable. In other words, it can be taken away or restricted in selected circumstances. So it says here in Article 10(2)(c), Parliament may by law impose such restrictions it deems necessary or expedient in the interest of the security of the Federation or any part thereof, or of public order or morality. So there are three grounds under which I may restrict your Article 10(1)(c) rights, okay? National security, basically, right? Public order and morality. Now, the question here is that is any law to deprive an MP of the MP seat once this person has ceases to be a member of the party under which he or she contested? Is this in any way a restriction on the right to form associations? Now, the right to form associations has been interpreted in a number of cases, both in Malaysia as well as in India and other jurisdictions, to include, right, managing an association, and which also includes the right to disassociate, in other words, to leave that association. So all that is a bundle of rights. So it's not just to form, right? It's also to join, to leave, to manage, and so on and so forth. Even so, right? If I say that there are consequences to you joining or not joining a particular political party, I do not, in fact, stop you from doing so. There is no law actually prohibiting you from doing that. You just got to know what the consequences might be. And so one of my big questions with this, just looking at the logic and the wording of the Constitution, how is this seen to be a restriction on the right to form associations? Okay, let's assume that it is, right? Will it be unconstitutional? Well, so far, the Supreme Court, as it then was in Nordin Saleh's case in 1992, states that it is. Question is, of course, does it stand up to scrutiny today? Is this still good law? Is it a very bad song, as Tan Sri Arif suggested just now? I have many problems with this case. I read it many times, trying to really understand, what was the basis of the judgment. And the judgment is actually not terribly long. There were two main judgments, one of Lord President Abdul Hamid and the other one by Gunchit Tuan, Supreme Court Justice. Now, the relevant provision in dispute in that case was Article 30(1)(a) of the Kelantan Constitution, which states that if any member of the Legislative Assembly who is a member of a political party resigns or is expelled from, or for reasons whatsoever, ceases to be a member of such political party, he shall cease to be a member of the legislative, and his seat shall become vacant. right? I think it's Legislative Assembly. I think there's typo error there. So what are the grounds for the decision for holding that Article 31A of the Kelantan Constitution violated Article 10(1)(c) of the Federal Constitution? Now, if you take away, all that, the ratio, the stuff about constitutional interpretation, dealing judges dealing specifically with counsel's arguments and the plethora of Indian decisions thought to be analogous being cited. Bottom line is actually just this couple of grounds. In the Lord President's judgment, it's very simple. If you want to take away any right under Article 10(1)(c), only the federal parliament may do so. And here, this was not enacted by the federal parliament. This was in fact enacted by the state legislative assembly. So you are violating the constitution in the sense that it is law that is not permitted to be made by a state assembly. Okay, and as a corollary of that, the grounds for disqualification in the state constitution should be based on Section 6(1) of the 8th schedule, and if you look at that provision, it doesn't include the cessation of membership. Gunchit Tuan, in his judgment, again used the same argument. Only federal parliament may restrict the rights under Article 10(1), but that came as a sort of an afterthought, because the first thing he said is, I can't see how an incursion on a citizen's rights under Article 10(1)(c) falls within any of the limbs of Article 10(2)(c). In other words, it's nothing to do with security or public order or with morality. So why are you even allowed to make such a law? It's not permitted under Article 10(2)(c). Then he goes on to make the point, therefore, in accordance with Article 4(1) of the Federal Constitution, the Constitution provision in the Kelantan Constitution violates that provision and therefore should be struck down. And finally, of course, the same point which the Lord President has made. My very quick comments with respect to this is that if you look at the Nordin Saleh case, right? Why would any disqualification provision necessarily affect a citizen's derogable right? You don't stop anybody from joining anybody. You don't stop them. You don't force them to join. You don't force them to leave. It's just that there are ramifications for your actions, and that would be the same case for almost anything. I mean, you can't join two political parties at the same time. I mean, there are ramifications, right? You're either with this party or that other party. So a restriction under Article 10, I think, needs to be read a little bit more narrowly, as opposed to covering every single instance of a possible restriction. Because otherwise, what you're doing is you're tantamount to turning the right to hold your seat into a constitutional right, to be almost an unenumerated constitutional right. And I think there's a major problem there. So anyway, even if it does, right, what is there to stop you from changing the law now? I know my friend Shad has once said it, I can't remember where, but I seem to have remembered him saying that, of course, it can fall within one of the Article 10(2)(c) provisions, because, morality is not just sexual morality, it's political morality, right? Correct me if I'm wrong, Shad, but I definitely remember you saying this. So the question here is that it is actually possible to interpret it a little bit more widely in so far as that was concerned. If you want to change the constitution, can you do so? What do you need to do? Well, first of all, you probably need to amend the constitution I'm not sure if Article 10 needs to be amended, but maybe to put the matter beyond doubt, perhaps an exception to Article 10(1)(c) needs to be inserted. You may probably need to amend Article 48(6) of the Federal Constitution as well, because there it says that if you've resigned, nothing to do with dismissal, but if you've resigned from your political party, you are disqualified for running for elections for 5 years. Now, I think that's going to be a problem for many parliamentarians. I mean, you know, if I leave and then I'm going to be disqualified and so on. So that's going to be a major problem. But really, I think that there is very, very little impediment to the change of the law at this moment. And even if you don't change the law, quite seriously, I think a federal court coming along, revisiting Nordin Saleh, might consider that this case ought to be restricted purely to the facts of the case, which was that a state legislative assembly was purporting to make a law which it was not permitted to do so, and that the federal parliament could, in fact, by federal law, whether by way of constitutional amendment or not, actually change the law. So let me pause there. I hope I've not overstepped my time. Thank you very much. I'll stop the share.
Thank you, Kevin, for a very interesting, and I join with Shad in saying that both Tan Sri Arif and Dr. Professor Kevin has given us a conspectus of the issues pertaining in particular to matters of parliamentary institution and the focus of anti-hopping. Perhaps we will open up for discussion, but Arif, maybe you can have a quick response to Kevin's exegesis of Nordin Saleh. Do you have a view of that? And you just
I have stated it many times. To my mind, Nordin Saleh was wrongly decided. I fully agree with Kevin's take on it. It's got nothing to do with the right to form associations. You can form any associations that you like, subject to all the restrictions, no doubt. But if you choose to party hop, and you have law saying if you party hop, you lose your seat, that does not interfere with the right to form an association of your choice. You can leave, you can form, you know, but there are consequences. So it's got to do with the right to form an association. But it is a political decision. If you look through the judgment, particularly in the judgment by Hamid, you will find that the court was using a minority decision in an Indian case to support this finding. They disagreed with the majority. And how did they disagree with the majority? I mean, I've got the passage here, all underlined, because I've been looking at this, like Kevin, I've been looking through this case, you know, time and time again, and I cannot see the logic behind the decision. But the political angle is here in this passage. Yeah? Let me read it. I mean, give me some time, because I think it's so important. For anyone interested, this is at page 710 of Hamid Omar's, Lord President Hamid Omar's judgment in the MLJ report. This is what it says. There are certain general observations which you'd like to make regarding Mian Bashir Ahmad's case, famous Indian case. It is obvious from the judgment of the acting Chief Justice that in upholding the validity of the impugned legislation, he had placed great stress upon what he described as the post-independence history of prevalent political defections and the baneful effect in that they had threatened the functioning of parliamentary democracy in many parts of the Indian subcontinent. He emphasized the great clarity and detail and so on and so forth. That is how the late Lord President read Mian Bashir's majority judgment. Now, Hamid Omar then says, this is important, the position in this country, Malaysia, the position in this country cannot, however, be said to be similar to the position in India then. For the background events to which we have briefly referred have no parallel here. Certainly no attempt whatsoever was made either by the introduction of evidence or even by way of argument to establish the contrary. This is not a decision based on a principle of law. This is a decision based on politics. I think we've got to call a spade, you know. So if you're deciding on the principle of law, you should, properly speaking, follow the majority judgment in Mian Bashir's case. Why do you follow the minority judgment? You know? So if this is correct, come another case similar to Nordin Saleh, we introduce evidence to show that, of course, it's politically unsettling. It leads to instability. That's why I'm a bit disappointed that you know, that Penang case was not fought. I think the state government should have pursued the matter, revisited Nordin Saleh, and maybe the court will look at the case differently, you know. But now that we have this evidence, Kevin has given us the years and the states and now the federal government. This is the overwhelming evidence that the court was crying out for in Nordin Saleh's case. So I fully agree with Kevin's take on this. But I am also not, you know, a believer that things will always be rosy on the judicial front. You know, they could just repeat the same argument. So that is why I would like to push for a constitutional amendment. Let the legislature sing that song, the good song that we like to hear. Let them do it. If they're talking and puffing the chest now that we need reform, and you know that party defection is one of the reform, please do a short amendment. Make it clear once and for all. But are they willing to do that? I don't know the answer. Yeah.
Ansari, you raise a very interesting question. Much as lawyers, we tend to vest a lot on aspiration of judicial power. All right, there are risks involved. What if they reinforce Nordin Saleh? All right, for whatever the reason, despite the able rejoinders that both Dr. Kevin and yourself has analyzed ably, and there is also a concept which I come across by a professor from UCL on political constitutionalism. All right, constitutionalism are not purely a juristic concept where lawyers adversarially argue and the executive lawyers try to counter-argue for wanting to preserve a status quo. Political will and actors must also embrace a form of political constitutionalism. Obviously, we can't unpack all what that means, but Tan Sri Arif has seen at the trenches, right, of political jostling in Parliament, how the will of parliamentarians could also be organized around a central concept. If the MOU works, all right? This is all part of the transitions we are going through that has thrown up wonderful issues where the rather staid and stolid Singapore Parliament won't face such issues, all right? We in Malaysia are always lively. Never a dull moment in Malaysia, Kevin. Shad, I'm sure you could make some comments. I would invite you if you care to.
Thank you, Phillips. Actually, I have nothing to add. I would agree with Tan Sri Arif that the courts could not be trusted in this matter, perhaps, because even if the court overrules, a later court may restore. So perhaps an amendment is what is necessary. I just wanted to add what Kevin has already mentioned. I do believe that Nordin Saleh was wrongly decided because the amendment to the Constitution, even if it were violating the right to association, was permissible under the ground of morality. Surely morality, taking bribes, hopping here, hopping there, surely that's morality. That's all. Thank you.
Fascinating. Using the existing language, can there be a more expansive, wider interpretation? I have seen some chats, and whether those people who posted on the chats would like to raise their hands and speak out, it's fine too. Obviously, I'm happy to allow discourse to take place on this area. Anyone would like to speak? Well, the lively chats are quite interesting. I also have seen a number of private chats going on, but the whole issue of the electoral will, the will of a sovereign people through the ballot box, resulting in the lower house, the House of Representatives, and how the dance of coalition and fragility of coalition threatens to undermine, and that was gesture towards, I think, Shad, you mentioned that in your discourse, quite interesting. Can a prime minister, all right, thwart the parliament vote of confidence? In some extent, it's linked, all right? After acquiring through anti-hoppers, the position of commanding the confidence and securing the appointment by the constitutional monarch as best having to command the view of the monarch, command the confidence, should the person not have a convention of allowing it to be tested. I can see that Dr. Amanda Whitting privately texts and say the whole Gough Whitlam incident is quite interesting also. When Gough Whitlam was dismissed by the governor, all right, and then the new prime minister came up, the caretaker for commanding, Fraser, I think, he committed himself to election, all right? To be fair to the Prime Minister Muhyiddin, he did recognize it in his proclamation of emergency over COVID that there is a need for election, though it could be deferred because of COVID. The combination of COVID, pandemic, emergency, command of confidence, and issue of testing it from the floor gave rise to perfect storm over issues of parliament. Would you agree to that, Tan Sri Arif? To some extent.
Yes, okay.
Yeah?
Yes. I mean, COVID has a part to play in it. Yeah. I think it's in a supporting role, not the main actor.
Yes.
Because despite COVID, we have seen how the other parliaments worked throughout the episode. There was no suspension of parliament. A vote of no confidence or confidence could have been organized.
Yes.
Changes could have been effected, as was done in Singapore, actually. Singapore met the COVID epidemic head on by amending its constitution. We have been waffling. Until today, we have been waffling. Can be done, cannot be done. Now it's in the back burner. No one really discusses on whether we should allow hybrid proceedings. It's taken off or back somewhere in the back burner.
I think the election thing also, the Sabah pre-vaccination, which gave rise to concern. But with vaccination and SOP, Malacca, although a lower turnout, did proceed fairly effectively. I note that Ms. Cheryl Stothard raises her hand earlier. Would you like to raise a comment, Ms. Stothard?
Yeah, okay. I just wanted to, I know I wrote a very long comment about constructive trust and all that. My point is not to raise a case on trust law, contractual law, but as an argument to take the question of party hopping outside the ambit of this constitutional, so-called constitutional right, freedom of association, because nowhere in the world is the fundamental right of freedom of association used to give a politician a right to jump all over the place. It is to help people have the freedom to join a union or a party or something that the state is trying to infringe on. So I don't understand why we can't I know the easiest way is to amend the constitution, but every time someone says constitutional amendment, I cringe in advance because our constitution has been amended so badly. So anyway, my point is, why can't we just take it out of the whole this whole constitution argument? Because I don't see any backup internationally that says freedom of association is to help politicians jump. It's like saying freedom of religious belief means I can freely kill you. You know, you can't say that, even though it's my freedom, my religious belief that I can kill you. So I think it's a distortion of the constitutional rights. That's my point.
Okay, Cheryl, thank you. You know, thinking out loud again, Kevin, could you make a comment? I remember reading that New Zealand and Canada, they do have code of conduct governing the parliamentarians, all right, whereby they have a fiduciary duty, all right, and this fiduciary duty has, in some way, especially in Canada, I did note, has some issue. I mean, this relates to Cheryl's comment. Isn't a member of a lower house a fiduciary, all right, for the office that she holds? What would you like to say about that? Is it possible, maybe Arif can add to the comment, to have a code of conduct, a charter of MPs committing to themselves, meaning the House is regulating itself that in the event you crossover, you hop, that is a breach of that fiduciary duty, and you could have your seat being vacated, and that the House is regulating itself. So why should the judiciary interfere with the House ruling, which generally they themselves can regulate themselves? That would be an interesting question to pose. Kevin, quick take, and maybe Councillor Arif can make a comment.
I can't say I've studied this in any great detail, but it's always a question of accountability and enforcement. And at the end of the day, you know, would you rather put this into some kind of an oath, some kind of a standing order, or would you do it through the Constitution? I think it's better to do it in the Constitution. I think maybe it's time for Malaysia to think about setting up a constitutional commission to have a nice review of the Constitution. There's so many things that were well thought out during the time of the Reid Commission, notwithstanding, you know, some of the aberrations, but you know, should be looked at again, really.
Arif, what do you think about the fiduciary duty of MPs?
I have my problems with that concept, actually.
Okay.
In the area of contract law, or trust law, or partnership law, they fit in well. But in the context of the political process, it gets very murky. Fiduciary to whom, and so on and so forth. So we're still back to the basics. You got to handle the Constitution and its problems. That is a good suggestion, Kevin. We should have a constitutional commission and a constitutional court to boot, so that cases that contain a constitutional dimension should be decided by at least a fixed quorum, and the Constitution of Malaysia can be developed, you know, in a more orderly fashion, so that you don't have this minority-majority issue that we are seeing now. It's luck of the draw, more or less, of who's going to sit. Some would favor ouster clauses, some would not, and so on and so forth. So if it's before a constitutional court, that should do the trick. And to have a constitutional commission looking at the problem would be good too. Look at the entirety of the problem. The emergency legislation, the ouster clauses, everything else that matters nowadays. So the short issue is, I'm not very, attracted to that notion of fiduciary duties. Yeah.
Thank you. Thank you for the quick comment. Shad, I see your hand raised.
Yeah. I share the indignation of the previous speaker, of our learned commentator, that there should be no constitutional issue here. It's more a case of breach of trust, as you put it, fiduciary duty. I share the indignation. At the same time, on a matter of principle, I do not like the idea that some things are purely for trust, some things are purely for contract, and the Constitution should not apply. I don't think the Constitution can be shut out from anywhere. If it is the grund norm, if it's the highest law of the land, it should apply in our homes, it should apply in our clubs, in our political parties, in our workplace. So I don't think we should look at it this way. The Constitution is not relevant here. This is more a case of trust or contract, because that would be a dangerous point, because then actually employers and employees, clubs and members, political parties and their members, they will say, don't bring the Constitution into the picture. This is between you and me. I think the Constitution applies everywhere, in my view.
Thank you, Chad. Dr. Amanda Whiting, you posed me a private question in the chat. Would you like to articulate it publicly? It's quite interesting. While we are now focused on preventing anti-hopping, isn't there instance of true exercise of conscience? All right, let's say a parliament that is captured by a complete demagogue, all right, including the party that the person has. And the party then wants to, person wants to leave that party, all right? Is it necessarily inimical, all right, in those instances? Obviously, this is not to subvert anti-hopping, but there is a cautionary note. Amanda, would you like to expand on that, or you prefer that I have just articulated it and invite the commentators to respond?
Philip, I didn't come prepared either for the camera or to speak, so I would just like to raise the question, and I would be interested in the idea of a conscience vote and also how party discipline fits with the notion of a conscience vote, and if we can differentiate between hopping, which is immoral, and a conscience vote, which might, if done in good faith, conscientiously be perhaps acceptable. That's all.
Thank you. Dr. Matthew Wiching has an abiding interest in Malaysian law and has written copiously on the Malaysian bar and also issues relating to this. Thank you, Amanda. The point is, let me just put it to the logic. Let's say a dominant party, all right, suddenly turn completely fascistic and completely subvert the constitutional norms. Is it necessarily wrong then for a member to say, I do not wish to belong to this party anymore? Right? What would you say to that, Arif?
Yeah. I mean, well, here I agree. There must be conscience. Although not fiduciary duty. Votes must be based on conscience. But of course, easier said than done, because the exercise and influence of the party whip in Malaysia is very strong, particularly now, when every vote counts, and every vote could be a signal for success or defeat. But in better times, I think MPs should be allowed to have a conscience vote. In the 2 years I was there was a point when there was some discussion on one matter, whether they should be allowed to vote according to their conscience. But of course, at the end of the day, everyone starts by the party whip. But there is no reason why we should keep on promoting this concept within a maturing system. I think that is why it is a larger issue. You got to work on caucuses. You got to work on a better, relationship between the opposition and the government backbenchers. That comes with a lot of political culture changes, I think.
Okay, thank you, Arif. Dr. Majid, can you make a quick comment? I saw you raising your hand. Unmute, please. Unmute yourself. Raymond, unmute Majid, please. Raymond, please unmute Dr. Majid.
Have I succeeded?
Thank
Can
you.
hear me now?
We hear
Yes,
you.
yes.
Just very speak.
I have a question to the constitutional experts. If you go to the case law on party hopping, you find that MPs come along and they write to the speaker saying, I have lost my confidence in the Menteri Besar, I now support the opposition. What has always struck me is that they make this bland statement and they're never required to give a reason. Should that be a requirement, that you give us a reason for your loss of confidence? Or would that defeat the system? All the cases that are reported seem to contain that formula that all the MP says is that I've lost my confidence in MP Menteri Besar so and so. I now support his opponent so and so from BN. And then the vote goes through. I've always wondered as I read that whether the MP should be required to give a reason why he lost confidence.
Interesting point. I think maybe Arif or can make a comment, but that is tied up also with the issue of a statutory declaration of why you have confidence. All right. Do you actually have to say why you have confidence, or you just say I owe undivided loyalty? And the specter of that in para, I remember, you can have one round of statutory declaration and then the person is appointed. When he hops, he makes another round of statutory declaration that he has changed his mind. Now he is loyal to another. Under the Statutory Declaration Act, I was wondering why no one is hauled up to say that you have breached your earlier statutory declaration. I mean, these are, in a way, public law, private law is intersecting here. But Majid's point is slightly more different. I think should anyone, when you want to give a reason for something, shouldn't you articulate the reason? Maybe like a director resigning, all right? He should give a reason. Or auditor for that matter, but that is private law discourse. Arif, would you like to make a comment, or even Kevin?
I think we start on the premise that politics can be very messy. Yeah. So they can have any number of reasons why they want to either not support or to support you.
Yes.
But the big point is this: it shouldn't really matter what is decided.
Yes.
Outset. You must support that decision by a vote of confidence or no confidence in the House. You can have any number of statutory declarations. I mean, one guy can have 4 statutory declarations changing over time, but have it tested. But this is what we wanted to have in 2020. Agung appoints a prime minister, but he must get it tested on the floor of the House. And if this is the political culture, the norm, that we can instill in Malaysia, it's going to be a stable country. You can hop, you can jump, I mean, even with Nordin Saleh, but you test it on the floor of the House, which in a way was done. My sacking, in a way, was a kind of vote of no confidence or confidence, you like it, but it showed to the nation and to parliamentarians themselves, he didn't have a lot of support. Your prime minister had only a majority of 2, but never mind, it was carried. So at that point in time, he had majority support of 2. That's it.
Yeah, if I may just supplement what you said, Arif, I think in the 2020 interview and document collection exercise that the Yang di-Pertuan Agong had, there were members of parliament who gave him 2 statutory declarations, one for A and one for B. And this is on the public record.
Actually, Raji, this is something which we do not know.
Well,
it's highly speculated. So, really, I personally do not know what went on within the palace walls and all that. So it can get to be a bit complicated. I mean, this is a level of high politics, which we common constitutional lawyers will find it difficult to understand and truly comprehend.
Philip, you are muted.
In some way, the para-crisis case, which drew the palace into assessing confidence by statutory declaration, has given rise to, maybe inadvertently, the palace being drawn into what we call the political thicket. And therefore, issues like this do raise concerns, I think. But how, in what mode should the palace assess best command confidence remains a very lively issue indeed. Would it be by stat dex? Is it not bound by that? On issues like earlier, short gesture to its about suspending emergency, this special committee, which some of us felt it's actually unconstitutional. There's no such organ recognized under the federal constitution. The whole conventions or practices surrounding the exercise of palace discretion are lively issues. And perhaps on Monday, and this is perhaps to tease the interest of our participants who are persevering to join us in this webinar, to attend our Monday evening deliberations, all right? And also earlier, Arif gestured to its constitutional court. Let me take the opportunity to also promote that on February 9th next year, we're going to have a Tun Sophian 12th Memorial Lecture, and we will have a very renowned constitutional jurist, Professor Dr. Dieter Grimm, retired Federal Constitutional Court, the German experience, mediating towards the Anglophone world about issues concerning establishment of constitutional court and constitutional decision-making by judges. But that is taking up time of the discourse and promoting Monday and February 9th. Let me now reopen it for further conversations before we head towards winding up this morning's proceedings. Any other person would like to raise issues or further comment? Majid, would you like? I saw that you seem to be eager to say something more.
I think it's been covered by the other commentators. Thank you.
Kevin, okay.
Yeah, sorry, just to pick up a few points that have been mentioned just now by various interlocutors and so on. I think on Amanda's point, I think it's important. I agree that a conscience vote is important, and there must be some way. I understand that the party whip problem is very, very real, but if some mechanism could be developed for within the standing orders of Parliament, for example, where let's say 1/3 of Parliament feel that a debate on a particular matter is of such great importance that party whips should be lifted, the whip should be lifted totally, then that should carry the day, and no one would then be penalized accordingly. Not sure how that's going to work, but I think that would make for, I think, a better form of debate where conscience can be reviewed without you necessarily having to resign from your party. But as your hypothetical put it, Philip, if a demagogue suddenly takes over the party, why do I want to be a member of this party anymore? But that doesn't mean that I should still remain a member of Parliament. I think that's the key here, right? Yeah, I just wanted to sort of chime in on that particular.
Sean, I can see you now back on the fray. Would you like to make contribution to this discourse, because you are a champion on public law and judicial review? Sean.
On this one, I don't have a comment more than what I said. Thank you.
No, sorry, not Sean. Shanmugam Kanesigalam, the lawyer. Sean, are you there? Shanmugam? Oh dear, Sean.
Yeah, Philip, but like Amanda, I'm neither prepared for the video nor the audio. But I was going to say there's a provision in the Constitution where if somebody resigns as an MP, he cannot stand in the resulting by-election, or in fact stand in any election for 5 years. I think that should be deleted, and that would also facilitate changes in conscience, where an MP who has a genuine change in conscience will stand for re-election in the by-election. Just wanted to point that out as well. Thank you.
Thank you. I also see one of our speakers for Monday on the screen. Nazim, if you're not dressed, you can address us audially. I mean, not dressed appropriate for a video. Would you like to make a comment, Nazim? Hi, Nazim. Nice to meet you online.
Hi, Prof. remember there was this comment by some constitutional experts in Malaysia that once the Yang Dipertuan Agong had appointed the Prime Minister, and that's it, it's legal. You don't need to have a vote of no confidence. I wonder what's the reaction, the comment from our illustrious speakers regarding that point.
Thank you. Arif, I invite you to make a comment on that.
Yeah, I mean, the point is clear. Of course, the appointment is legal.
Yes.
But do we stop there? If you are truthful to the Constitution and to the political process, it has to be tested on the floor of the House. I mean, that is the basic principle. Whether or not you command the majority of the members of the House, the judgment of the Yang Dipertuan Agong is something quite different. It is a discretionary judgment. His Majesty will then decide who is likely to command the confidence of the House. It's a likelihood situation. We want something more exact on the floor of the House. So thereafter should be put to the vote. Actually, when it came to the appointment of Ismail Sabri, the palace issued a statement, didn't it? That His Majesty hoped that the matter would be subject to a vote of confidence. That was in the statement issued by the palace. So I think here we see some suggestion that this is the proper way to do things. Yeah? Each will act according to his sphere of authority, but we must never forget that our system is a system of parliamentary democracy. So Parliament has the final say, as it should, as a representative of the people. But these are the basic principles. Sometimes people lose sight of, these high-flying commentators. They talk of legalities, but what is the political process? What is the first principle? Parliament is a representative of the people, and Parliament must have the final say. So that's my view.
And then the constitutional organs, which is recognized, the Yang Dipertuan Agong, His Majesty's office, the parliamentary role about confidence, which is in Article 43, 4, all right? The whole issue of testing confidence, though not articulated explicitly, clearly Parliament should not be suspended, just as Boris Johnson tried to do that, all right? Prorogue ad infinitum, therefore causing the issue of legitimacy of the continuum, and more so when someone acquire office, the highest office of executive, the legitimacy issue, there's an overhang. And if you allow a test to be taken, in some of my open ad piece, we saw that happening by Tun Hussein On, right? When Hussein On took over, there was a motion and it was given acceptance that majority support. In fact, it was unanimous, all right? Nobody dissented at that stage, because I guess the Barisan Alliance controlled more than 2/3, so that became a non-issue. Nonetheless, the convention, there is, whether it ripened to convention is another debate, was that it was, there was a vote of confidence, all right, by Hussein On, therefore legitimizing his continuance as a prime minister when he took office, all right. Kevin, do you put up your hand?
Yes, I did.
Okay, go ahead.
Very, very quickly, I wanted to endorse the point which Arif had mentioned just now about the confidence of on the Prime Minister being, demonstrated on the floor of the House. Actually, I was really surprised that the Federal Court chose a Nigerian precedent and adopted it instead of adopting its own precedent, where, in the Stephen Kalong Lincoln case, it was clearly stated that actually in these circumstances, confidence should be demonstrated on the floor of the House. Now, I think this has major implications insofar as the discretionary power of the Yang Dipertuan Agong is concerned. So I think this may be something you will discuss on Monday, but just again as a teaser, the question is, if the Yang di-Pertuan Agong makes a decision and you think the decision is wrong, question is, can you get judicial review of that particular decision? You know, and the one on the selection of the Prime Minister, or in the case of the states, the Menteri Besar, this comes up all the time, because then you say, well, on what basis did you make this decision? Is it a decision that, you know, was one that was reasonable? The easiest way to put everything at rest is to simply say, look, was it tested on the floor of the House? If it was, you know, it was perfectly reasonable for me to exercise my discretion in this way. I mean, in fact, in the Padang Kirigan case, although it was only at a high court level, it was this massive judgment by Justice Tan Chow Tong, where he actually went into the decision whether or not the decision arrived at by the governor was the correct one or was something that could be reviewed. And he came to the conclusion that there was no way it was a proper decision because it had been made under duress. So when you talk about the exercise of the ruler's imperative or the discretion, you want to shield it as much as possible from judicial review. And the way you want to shield it from judicial review, especially in respect of choosing the Prime Minister, is to simply say, look, you are a parliamentarian, we are running the Westminster system, the executive branch is drawn from the legislature. Let's have a look at what the legislature has to say.
Yeah. I think it's very interesting what you just said, Kevin. The Azlan Shah's decision to look at the settled tax in a way through a long shadow, but the backstory for that is a bit more complex. Perhaps we can examine that on Monday. All right. I was vitally involved in the litigation to the Apex Court. So was I in the Pyrins case, where Tan Chow Tong made a ruling on interesting issues on justiciability, conventions, and also free from duress. All right. These are really powerful, interesting cases. And you gesture towards Adingborough and Akintola. Again, that one, we will ask Andrew Harding to tell us his narrative on Monday, because when he was teaching in SOAS, he told me about a very interesting narrative. So again, I'm giving some sort of a promotion to Monday, all right? So that 33 of you, or 32 now, or 31, who have persevered with us would return and tell the rest of the stakeholders in the legal fraternity to join in our discourse. I would like to actually wind down the conversation, and I would like to first of all especially thank all participants who have joined in this conversation this morning, but in particular, of course, our very learned speakers that commenced in the morning, Professor Emeritus Shad Faruqi, my esteemed legal fraternity member, Ms. Carrot Chia, and now, of course, Tan Sri Arif Yusof, and my good friend Kevin, who has enlivened our understanding, enriched our horizons, given us insights that are not just theoretical discussion, but there are practical implications, both with historical backdrop, contemporary reflection. These issues are pervasive, they are perennial, they are permanent in our landscape. But as Dr. Sri Azlina and our Dean has mentioned, all issues concerning public law, there are moments in our reasoning that we could revisit. They are never ossified or paralyzed. That doesn't mean that it's so fluid that everything is relativized. As lawyers, we know that there are constraints both in the text of our constitution, in the way judicial interpretation takes place, but we should never give up hope that all stakeholders, and I think this is a point made by Jeffrey Marshall in a very important book on constitutional conventions and people writing on that area, that all actors, including political actors, ought to exercise critical political morality, positive morality in the way we conduct ourselves. Unless, in the phrase of Shad, unless constitutionalism is practiced both in substance and within our own souls and hearts, and the wills of every actor in a legal order or political order, then and only then will the Constitution be a living document, something that we all aspire for. This is why the University of Malaya and Law School engendered such conversations. This is how we hope that this morning conversation has led and reinforced this commitment. With those remarks, I would like to close this session. I thank Tan Sri Arif especially and Kevin for joining us across the causeway, and all of you who participated in the lively chats. And I hope that you will join us again on Monday as scheduled for a very important segment on the role of the constitutional monarch and issues concerning exercise of who is a sovereign, and does the Constitution matter in times of crisis. With those remarks, I bid you farewell and a good weekend. Thank you so much, and thank you for those who are operating the platform and the Faculty of Law. Thank you. Bye-bye.